of 2006. The suit was decreed, and the appeal was dismissed by concurrent findings recorded by both the courts. Mr. Bajus, since there is delay, in view of the fact that this court is not inclined to condone the delay in filing this appeal is dismissed.
Orders item 1 second April 275 or 2002.
Order dated 16/3/2005. Starts with a substantial question of law is changed. Since Lordship, I have one more substantial question of law is that is already incorporated in my second appeal. That is also required to be addressed in this proposal.
We have already freed the substantial question of law. Further, there is no such liberty granted, and there is no intermediary application seeking to.
Since it is already there, Lordship, in my second
You
appeal.
should have pointed out at the time of claim of the substantial question of law. You must have been heard fully.
Must have been.
Must have been. I assume that you were heard, and yes.
Yes, Lordship. This is, if Lordship permits, in course of argument that will come, Lordship, therefore. Whether the findings were correct, this is also very important, and other one is also important. That is also based on entirely a legal fact, the legal ground, Lordship. That I'll just be pointing out. Since Lordship, the DCLR.
At the time of, unless there is an intermediary application seeking initial substantial question of law, at this stage, you just not on your mere asking you just can't give, you cannot. That is a separate thing that during the course of hearing, if the court feels that there is
Yes,
substantial question. Otherwise, you can start with it.
I'll not start, Lordship. I'm just indicating that it will be
We have a
required.
substantial question of law. If we find that yes,
Yes.
there appears one more, then the court can always take it.
Yes.
But not on your asking.
This is Lordship, whether the findings were correct in lower appellate court regarding the genuineness of the plaintiff's documents being based on only doubts and surmises, the same as verbal
You are the plaintiff.
plaintiff or plaintiff. So may I give certain facts of the case? That's the
You can
Yes.
trace it from the improved judgment. Facts has been correctly recorded. Or like recorded. Recorded in a
plaint se theek rahe.
Well,
Because I have prepared for my plaint.
that I take it from the
Plaint is long, Lordship, if Lordship permits, my learned friend is here. He will be indicating if something wrong I have said.
Yes.
That will be better because it will also be easier for the court to
That's
understand.
certainly.
The case of the plaintiff, Lordship, will kindly hear, Lordship will find everything. It was a plaintiff father, Lordship, was settled in Zarayat by Kamakhya Narayan Singh. Just cutting short the matter because earlier one Khewardar was there. The Khewardar died issueless, and therefore it was resumed by the superior landlord, Raja Kamakhya Narayan Singh. And from his office on 20/12/1942, that is Exhibit 7 without objection. 20/12/1942. The Hukmnama was granted. in favor of the father of the plaintiff, Gunju Sahu. Gunju Sahu.
Plaintiff,
Lordship.
father of plaintiff, Gunju Sahu.
Gunju Sahu.
Who was the ex
Kevartar.
Kevartar? Not mentioned.
It was
No
not
problem.
required also. जरूरत
Not
नहीं।
required also.
हाँ हाँ,
So, forget
इसमें
about it.
इसमें dispute नहीं है।
इसमें कोई dispute
हाँ, और that was for plot number 399. In खाता number 2, plot number 399, area 8.57 decibels.
Just this Humna.
This home number for 2 plots, and this is under dispute.
And the khata number?
Khate number 2, plot number 399,
Plot number 399.
area 8.57 decibels.
8.57
acres.
acres.
And second plot is 1900.
1900.
That was for area 3.30 acres from the same khata. But the dispute is only with khata, plot number 399. That is the suit.
Plot number
399.
399. And the entire area is in dispute?
Entire area, 8.57. Actually, it will not be entire area because we'll come to the fact later on.
Okay. But the suit property is this?
The suit property is this. Because we wanted for a declaration of right, title and interest over this land. Only this land. Now, Lordship, the total area of the Hukumnama was 11.87 acres. That's Exhibit 7. Adding both the areas. 11.87 acres. Now, the second line of the story is.
Just a moment. The learned counsel for the appellant submits that the substantial question of law has been framed by this court by order DT.20.12.2025. He submits that the appellants are the plaintiff who have lost in both the courts. The learned counsel has further submitted that the plaintiffs are claiming the property through the Hukumnama unregistered.
Unregistered.
Sada Hukumnama dated 20.12.1942 Exhibit 7, which was marked without any objection. The total area under the Hukumnama was 11.87 acres, which consisted of 2 plots in Khata number 2. They are plot number 399, area 8.57 acres, and plot number 1900, area 3.30 acres. He submits that the Hukumnama was executed in favor of the father of the plaintiff, namely Gunju Sahu, and the suit property involved in this case is regarding plot number 399, and the scheduled property is plot number 399, area 8.5 acres.
Now, Lordship, the second line of the story is. ये एक हो गया story. दूसरा story ये है.
So, आप prayer इसका quote करेंगे. Plaintiff. Prayer इसको quote करेंगे.
Second story, we have just brought that story in the print so as to ascertain that we were the original rayers of that village. Actually, that is also important. Of village Pakri Barwadi.
The dispute is in relation to village
Pakri Barwadi.
Pakri, P-A-K-R-I,
Pakri Barwadi.
Barwadi, B-A-R-W-A-D-I-H, district. District?
Hazari.
District Hazari.
Moja Badka.
Mauza Barka Gaon.
Now, of the village Pakri Barwadi, we also had a Rayati land. That was in plot number 400, 401 and 400.
400.
401 and 402. And after getting the Hukumnama of plot number 399 and 1900, the plot number 399 was amalgamated with our ancestral land.
This Rayati land was your ancestral land?
Yes. My great grandfather became the absolute owner of the Rayati land. My my grandfather, sorry.
Okay.
Namely, Bal Govind Til.
Bal
Govind
Govind was your grandfather.
Grandfather.
Who was the rayat in connection to these properties?
2-3 brothers. Details are there in the print.
The learned council has submitted that in the same village, with respect to plot number 400, 401 and 402 of khata number 2.
Yes, same.
Of khata number 2, the property belonged to the family of.
So khata number 59. Khata number 59.
With respect to khata number 59.
So khata number 2 to huzur kya bujirwa?
Are you sure?
Yes, that is.
Sort of. 400, 401, 402 is with respect to khata number 59.
Not sure.
In the same village.
In the same.
The ancestor of the plaintiffs had rayati land.
And that is also by Exhibit 10.
Which has been exhibited before the learned court by Exhibit 10. He further submits that upon acquiring the property through hukumnama dated 20.12.2025, the plaintiff's ancestor, namely Bal Govind Til, had amalgamated.
No, not sure. That by that time he died.
Okay.
Gunju Saab.
The
Father.
The father of the plaintiff amalgamated plot number 390, the land in plot number 399, khata number 2, acquired through hukumnama in the ancestral property.
Because Lordship will find 400 और 399 अगल बगल. That is, we have also an explanation. Not in this one.
The plot number 400 in khata number 59 is adjoining to plot number 399
of
khata number 2.
And after the vesting of the estate, actually before that, Lordship, the Jamindar also granted rent receipts.
With respect to the entire property.
Plot number 399, because that is in dispute. 399 and 119.
Zamindari rent receipt.
Jamindari.
What is the date? And exhibit.
बस यही 2-3 डॉक्यूमेंट इंपॉर्टेंट है.
I am able to base it. You tell me what is the date?
Not sure. Jamindari rent receipt dated 15/2/1945.
1945. Only one?
That is Exhibit 4.
Only one?
That is for 4 years.
Exhibit 4. This itself was for 4 years.
Yes.
4 years means it relate from 1941.
42 to 45.
42 to 45 तो 4 years नहीं हुआ ना?
हो जाएगा.
42, 43, 44, 45. 4 years.
वो दूसरा वाला साल लिखा हुआ है. That is 1999, 2000, 2001 and 2002. वो वाला minus 57 करने से वो विक्रम संवत है.
It is corresponding to Vikram Samvat.
1999,
1999,
2000,
2000,
2001
2001.
and 2002.
कितना माइनस करना होता है?
57.
Yes. This is the only length.
Not sure. That is Exhibit 4.
The learned counsel submits that after issuance of hukumnama dated 20/12/1942, the ex-landlord,
Not sure. Excellent.
Issued
Ramgarh Raj.
ex-landlord of Ramgarh Raj issued rent receipt dated 15/2/1945 within bracket Exhibit 4 for 4 years. For previous 4 years,
Not sure.
that is from 1942 to 1945. He submits that the year mentioned in the exhibit 4 is Samvat, Vikram Samvat 1999, 2000, 2001 and 2002, which upon deduction of 57 years would come to English calendar year 1942, 1943, 1943, 1944
and this was also without objection.
He submits that even this rent receipt was marked without any objection from the side of
By subject matter. Now, after vesting of the Jamindari option, the plaintiff was recognized as the tenant. The father of the plaintiff was recognized as a tenant. And the rent receipts were granted till 1981-82. Since that we have exhibited, still in the, that is out of the, not in the record, still here our name is there in online proceeding also.
The learned counsel has further submitted that upon vesting of Zamindari, the father of the plaintiff was recognized as a retainer, and for the disputed property,
Yes, sir.
for the disputed property also, and the state accepted rent from the father till the year 1981-82.
White exhibit 5Cs.
White exhibit 5 Cs.
5A and 5B.
That 5A
5A
and 5B.
This was also without objection.
These rent receipts were also marked exhibit without any objection.
One exhibit 6 is also important. This is exhibit 6 Lordship, which has been also marked without objection. That is the letter of one beat officer of Badka Gaon.
One
Beat officer. ये forest officer होते हैं beat officer. At that time beat कराते थे अब शायद
officer of Badka Gaon.
Badka Gaon. Average.
Yes.
I'm just reading 4 line later. प्रमाणित किया जाता है कि खाता नंबर 2/56 दोनों हमारे
56 अभी 59 में लिखा
है। सॉरी 59 प्लॉट नंबर 399 उसी का प्लॉट खाता नंबर 2 है /56 लिखा है व्हाटएवर इट इज प्लॉट नंबर 399 रकबा 8.57 डेसिमल्स हिंदी का एकर्स अभी प्रमाणित किया जाता है खाता नंबर 2 प्लॉट नंबर 399 रकबा 8.57 एकड़ जमीन ग्राम पकरी बरवाड़ी थाना बड़का गांव जिला हजारीबाग में है। यह गुजू साहब वर्ल्ड बाल गोविंद साहब गुजू साहब में फादर बाल गोविंद में ग्रैंडफादर पकरी बरवाड़ी के नाम से दर्ज इंडिकेटिंग है। उक्त जमीन में गुजू साहब के सहमति से ही सन 1974 में जंगल विभाग ने जंगल लगाया था एंड ही इज द बीट ऑफिसर ऑफ 1974 में जंगल विभाग ने जंगल लगाया था। उक्त जमीन पर जंगल विभाग का कोई दावी नहीं है, कोई दावा नहीं है एवं इसके मालिक गुजू साहब है। दिस इज द लेटर ऑफ द बीट ऑफिसर ऑफ द स्टेट गवर्नमेंट ऑफ द फॉरेस्ट डिपार्टमेंट।
State is not department.
स्टेट इज
State is a
हाँ 15 से 18 स्टेट की। तो and this exhibit 6 were not considered at all by both the groups. They have just brushed aside कि उसमें पहले क्या ज्योलॉजिकल सर्वे का वहाँ पे काम हुआ, उसके बाद जब लोग चले गए तो वहाँ जंगल विभाग के द्वारा वृक्ष लगा दिया गया। जब उसके बाद ये सारा जमीन जो था, now the story comes.
The learned counsel has also referred to Exhibit 6, which was marked without any objection,
Yes.
and submits that this is a letter of one beat officer who is a government officer,
Yes. Mahendra Lal.
Shri Mahendra Lal, who was from of village Barkagaon,
Badka. Beat officer Badka.
beat officer Barkagaon, named
District
Mahendra Lal. And as per this letter,
He has certified this certificate.
and he has certified that the plot number 399, area 8.57 acres in khata number 2/59,
Lordship. 56 लिखा है.
2/56 is recorded in the name of father of the plaintiff,
और उनकी सहमति से ही जंगल विभाग ने जंगल लगाया.
and the forest department, with the consent of the father of the plaintiff, had planted trees on the property
In 1970.
in the year 1974, and has also asserted that, and has also certified that the forest department has no claim over the same land,
And the owner is Gujusa.
and the owner is the father of the plaintiff, namely Gujusa.
Now, Lordship, the story of the defendant comes.
So what was your cause of action?
Cause of action. Now, cause of action was that since some lands out of this plot number 399, several persons were settled by the state government, and 2 persons approached the court of the DCLR after getting such settlement of 50 decimals each. And on their instruction and on their complaint, the DCLR directly cancelled my rent receipt without any issuance of notice, without any show cause. Although our name was already there in registered, that has also come in Exhibit D of the state, which was filed by the state. Order of the DCLR.
The learned
इसमें
counsel,
थोड़ा सा होता है. पहले DCLR का order हुआ, then we preferred an appeal. Appeal was also affirmed. After appeal, we filed a revision before the commissioner. Commissioner set aside the order and thereafter remanded back to the AC. And thereafter the AC Lordship again affirmed the order of the DCLR. But since it showed that the entire state government were inclined to pass an order in their own favor, because they have done all these things. Therefore, we preferred to file a suit before the honorable court so that we can get the matter decided once for all. That is the cause of action.
that's it. The learned counsel for the appeal submits that the cause of action to file the suit arose when some portions of plot number 399 was settled in the name of private respondent hearing. Private respondent को settle हुआ
Defendants.
हाँ,
Defendants.
to the defendants,
1 to 14.
defendant number 1 to 14 by the state, without any notice by the state, without any notice
Or ishtihar, that is the word used.
or क्या बोलते हैं, इश्तहार,
Ishtihar.
and ultimately those persons had moved the office of DCLR for the purposes of issuance of rent receipt. And the DCLR cancelled the rent receipt of the plaintiffs unilaterally and without any show cause. Such order was challenged by the plaintiff before the appellate authority, and the order was confirmed. Thereafter, the plaintiff went before the judicial authority, the matter was remanded. And ultimately, the order of the DCLR was sustained
Sustained by the Is
by
additional.
the additional collector.
And that is exhibit D.
By exhibit D. No, that is not exhibit D. Register 2 is exhibit D.
Exhibit D. D by the state.
And exhibit D by the state.
And moreover, Lordship, if 1G2 was not cancelled, only rent receipt, two rent receipts were
The
cancelled.
learned counsel submits that the name of the plaintiff slash his ancestor continued to be there in register 2, which was marked as exhibit.
रजिस्टर 2 एग्जिबिट नहीं हुआ है, ये हम रेफरेंस ले रहे हैं एग्जिबिट डी से, उसी में लिखा हुआ।
Although register 2 has not been exhibited, but a reference has been made in exhibit D,
The order of the DC.
which is the order of the DCLR, which shows that the name of the father of the plaintiff was appearing in the register.
Order of the additional collector. After remand order हुआ था, additional collector.
Order of the additional collector
Dated 4/6/1986.
dated 4/6/1986,
6.
within bracket exhibit
Exhibit D.
D.
A B C D वाले.
और कहानी क्या है? That's all.
समझ लो। ये हमारा हो गया, इसके बाद इनका आया कि इनका पर्चा आ गया, सब कुछ हो गया।
Who is in possession?
Possession is the crux of the matter. Now, since it is admitted that since 1974 we were in possession, they have stated in the WS that they got the parcha in the year 1979. But as per Exhibit C, the Bandobasti case lordship was itself registered for Hari Narayan Paswan, the main person lordship. This is also exhibited by the state.
Bandobasti case.
बंदोबस्ती
Number?
बंदोबस्ती पंजी का नकल लिखते हैं। केस नंबर इज वाद संख्या 52 of 1976-77।
This is with respect to all of them.
So, with respect to Exhibit C.
It culminated in passing of final order when?
Several cases are there, Lordship. Several case numbers are there. हम एक का reference दे रहे हैं इसमें। Harinarayan Ram, because he was the person with whom we had first interacted, and he has stated that in 1975 he got the parcha. The case number itself, Lordship, is 76-77. We are admitting कि ऊपर नीचे हो सकता है, no problem. 50 decimal land was allotted to each of them, 1 to 14, by the state.
Yes.
That is the case. And thereafter, Lordship, they say that they wanted to be in possession, and thereafter they have moved all these things, and we filed a suit. And till suit, Lordship, we were in possession.
This is what you claim.
Lordship.
This is what they claim, or this is what
This is our claim. We are still in possession, and that is my prayer.
The learned counsel submits that 50 decimal of land was allotted to each of the private respondents.
Defendant Khalid. Each of the defendants
To each of the private defendants.
are 1 to 14.
1 to 14. He submits that one such case in relation to
Hari Narayan Paswan.
Hari Narayan Paswan, who was the defendant, who was also the defendant, is Bandobasti case number 52 of 1976.
He is defendant number 1.
In bracket defendant number 1. He submits that this person claims to be in possession of the property since 1975,
As per their WS.
as per their written statement, but the Bandobasti case itself was instituted in 76-77. ये सब का क्या स्कोप?
स्कोप है, क्योंकि ये WS में ही जब इनका स्टेटमेंट गलत हो रहा है, उसके बाद कुछ केसेस और 81-82 का भी। Everything has to be seen Exhibit C. Now, Lordship, our prayer was that it be declared that the plaintiff has got subsisting right over the Schedule A lands, and the purchase granted to defendant number 1 to 14 do not affect the right, title and interest of the plaintiff. That is the main prayer we wanted. That the position of the plaintiff over the suit land be confirmed, and in alternative, we have also an alternative. If it is found by the court that the plaintiffs have been dispossessed, recovery of possession be effected through the process of court. Since Lordship, the entire state was with them, therefore it was an apprehension that we may also be dispossessed. ये तो धान खेत था, टाण था, a big plot is there, and खाता number 2 has a very big plot, 399 to about 60 acres is there. Out of that, only 8.57 acres were settled to us. Now, on this background, Lordship, both the courts, Lordship, I'll only come to the exhibits since that is the substantial question of law. And the second is that whether the DCLR or the AC has a right to cancel the subsisting jamabandi and the rent receipts on their own. And I'll just be reading the paragraph, how it was shown to have been cancelled. That paragraph exhibit D I'll be reading, Lordship. These are the documents, Lordship. Now, both the courts have come to a concurrent finding that all the documents are disbelievable. हुकुमनामा disbelieve कर दिए, हमारा जमींदारी rent receipt.
State contested the case.
State only filed WS. None of the person was examined on behalf of the state. One DW8 was examined. He is the Karmachari of the state, but he has categorically stated in his cross-examination that he is coming to give deposition on behalf of the private defendants 1 to 14, not for the state.
The council has submitted that the question of bandobasti by the state would only arise if the property belongs to the state. Correct?
Correct.
उनका स्टेट का प्रॉपर्टी होगा तभी ना बंदोबस्ती करेंगे.
हाँ, स्टेट कहा कि हमारे पे बेस्ट हो.
Would only arise if the property belonged to the state. He submits that the state had filed written statement, but no witness was examined on behalf of the state. One Karamchari of the state was examined as DW8. However, in his evidence, he has stated that he had deposed on behalf of the private defendants.
Private defendants. So now,
तो जरूरत नहीं है.
check.
अब the entire story is here.
Now, what the learned trial court has done, not sure. अब एक एक exhibit खाली देखा है, क्योंकि सारा केस वो exhibit पे है. अब exhibit C पे आ गया. Sorry, exhibit 3. Exhibit 4.
We will take it, whatever you have said, we will take it as correct. Now let us see the findings.
हाँ.
Whatever you say,
हाँ.
there is no reason. इन्होंने जो बोला है गलत बोला है किसी में से. सब सही बोले, इसमें कोई दिक्कत नहीं. एग्जिबिट देखने की कोई रिक्वायरमेंट नहीं.
एग्जिबिट पे सारा केस खत्म कर दिया. वो सारा एग्जिबिट को ही डिसबिलीव कर दिया.
हाँ देखते हैं.
हाँ.
कैसे डील किया है देखते हैं.
हाँ.
क्योंकि सब्सटैंशियल क्वेश्चन ऑफ लॉ बना ही.
Yes. अपडेट.
कुछ डॉक्यूमेंट हैं जो हुक्मनामा का पहले का है, इसके कारण थोड़ी
देखते हैं.
वो भी इसलिए मैग्नीफाइंग ग्लास लेके आए, उसको देखना पड़ेगा.
कोई बात नहीं. आप एग्जिबिट की रिक्वायरमेंट नहीं होगी क्योंकि उस तरह का सब्सटैंशियल क्वेश्चन ऑफ लॉ नहीं.
अपडेट कोर्ट का जजमेंट जरूर देखें.
ट्रायल कोर्ट देखें पहले.
ट्रायल कोर्ट. पहले फिर हम लोग इश्यूज देखेंगे.
नहीं, उनको आराम से.
पैरा 7.
आपको सुनेंगे पहले सुनेंगे. पैरा नंबर
पेज 7 हुजूर इश्यूज जो है.
पेज 7. यस.
पैराग्राफ ऊपर से. इस प्रकार उभय पक्षों के द्वारा लाए गए वर्णित वाद के तथ्यों के आरोप में न्यायालय द्वारा विचारणा हेतु निम्नलिखित बात निर्धारित की. क्या वर्तमानवाद जैसा कि दाखिल हुआ है कायम रखने लायक है? क्या वादी के वर्तमानवाद दाखिल करने का समुचित कारण पैदा हुआ है? क्या वर्तमानवाद विविध अधिनियम के प्रावधानों के साथ प्रतिकूल कब्जे के सिद्धांत से बंट? दिस इज फॉर एडवर्स पोजीशन because this also we claim. In paragraph 21 of our plaint, we have stated about the adverse position also.
You claim adverse position.
Also that also.
They also claim adverse position.
And they are claiming through Persha.
The learned counsel has also submitted that a plea of adverse possession was also raised on behalf of the
Specifically in paragraph 21 of my plaint.
in paragraph 21 of
क्या वादी को विवादग्रस्त भूमि पर स्वत एवं कब्जा है? क्या वादी प्रार्थी लिखने के हस्ताक्षर है? क्या वादी के अनुशोच का अधिकार है? घ और च कर रहे हैं लोग, राइट टाइटल इंटरेस्ट और वेदर वी आर एंटाइटल्ड टू एनीथिंग. पैराग्राफ 5 आया है. महत्व एवं सुविधा को मद्देनजर रखते हुए दोनों महत्वपूर्ण बात बिंदुओं के संबंध में सबसे पहले वर्णन करना आवश्यक समझता हूँ. यह भी वर्णन करना आवश्यक समझता हूँ कि उभय पक्षों के अनुसार विवादग्रस्त खेसरा की भूमि गैर मौजूदा खास थी, जिसके संबंध में वादी की तरफ से दावा प्रस्तुत किया गया है. भूतपूर्व जमींदार दिनांक 20/12/42 को हुक्मनामा प्रदर्शनार्थ के द्वारा वादी के पिता गुजू साहब के नाम बंदोबस्ती कर दी गई और तब से वादी के पिता जीवनोपरांत उस पर कब्जारत रहे और भूतपूर्व जमींदार को उससे संबंधित लगान की रसीद देते रहे और मरने के बाद वादी के द्वारा लगान का भुगतान किया जाता रहा. जब भूतपूर्व जमींदार की जमींदारी समाप्त हुई तो प्रतिवादी बिहार सरकार की वादी एवं वादी के पिता को विवादास्पद भूमि के संबंध में रैयत करार दिया गया और वादी के नाम से जवाबबंदी कायम कर लगान का रसीद देकर किए गए और तब से वादी के उस पर आज कब्जारत चले आ रहे हैं, उस पर कृषि कार्य करते रहे हैं. मगर प्रतिवादी 1 से 14 का पक्ष बिहार सरकार द्वारा विवादास्पद खेसरा की भूमि को की गई बंदोबस्ती से उनके स्वत पर एक कालिमा छा गई है. अतः वर्तमान वाद लाया गया है. मगर जैसा कि प्रतिवादियों के वाद से तथ्य है कि विवादास्पद खेसरा की भूमि पुराने सर्वे के समय के प्रतिवादियों संख्या 1 से 14 के पक्ष में सन 1975 को की गई बंदोबस्ती के समय क्रमशः गैर मौजूदा खास एवं बिहार सरकार की भूमि थी, जिस पर कभी भी कोई दावा प्रस्तुत नहीं किया गया और न कभी वादी के पिता का नाम में किसी भूतपूर्व जमींदार या बंदोबस्ती की गई और न ही उस बंदोबस्ती को बिहार सरकार द्वारा रिकॉग्नाइज किया गया. अतः स्पष्ट है कि वादी द्वारा कथित हुक्मनामा दिनांक 20/12/42 के को बंदोबस्ती के आधार पर वर्तमान वाद के लिए सबसे महत्वपूर्ण है. अतः इस संबंध में पक्षकारों की तरफ से लाए गए मौखिक एवं कागजाती साक्ष्यों के संक्षेप में वर्णन करना आवश्यक समझता हूँ. वर्तमान वाद बिंदु के संबंध में वादी की तरफ से कुल 13 साक्ष्यों को न्यायालय में पेश कराया गया. इसके बाद
इसका तो रिक्वायरमेंट नहीं
होता है. एक बार
बताइए और क्या पढ़ना है.
हाँ, एक बार उसको पैराग्राफ पेज नंबर 12 आया है. हाँ, उसका लास्ट 10 लाइन्स. जहां तक प्रतिवादियों 15 से लेकर 18 हाँ, ये दिस इज द स्टेट, देयरफॉर इसका हम पढ़ना चाहते हैं. जहां तक प्रतिवादी 15 से 18 की तरफ से प्रस्तुत किए गए साक्षी का प्रश्न है, इनके तरफ से प्रतिवादी संख्या 8 नागेश्वर प्रसाद सिंह का परीक्षण कराया गया है, जो बड़का गांव के अंचल कब्जा है. दिस इज व्हाट आई हैव जस्ट वांटेड टू पॉइंट आउट. ये जो बड़का गांव नागेश्वर प्रसाद सिंह जो है, ये कर्मचारी जरूर है बट नॉट हैज.
ये इतना
नहीं, वो अपने डिपोजिशन में लिए.
आप पढ़िए ना, आप
जी, ये हुजूर उनके डिपोजिशन से हम बोल. कर्मचारी का कथन है किए गए बड़का गांव के कर्मचारी का पद जून 1972 से लेकर 1970 तक प्रस्थापित थे. पुनः 24 जून 1992 से भी वहां पर कर्मचारी पद पर प्रस्थापित थे. यह साक्षी कथन किए कि विवादास्पद भूमि को वो देखे हैं, ग्राम पकरी बरवाडी में है और ये जमीन सन 1972 में सरकारी जमीन थी तथा उस समय जियोलॉजिकल कैंप था. मगर वो कैंप उठने के बाद विवादास्पद भूमि खाली की गई, मगर उस पर किसी का जोतपात नहीं था. यहाँ साक्षी आगे कथन किए हैं कि विवादास्पद भूमि को बंदोबस्ती हेतु सरकार से आदेश दिया गया था, अतः वे स्वयं मौके पर जाकर नापी कर उससे 12 व्यक्ति के नाम पर पर्चा बनाकर बंदोबस्ती कार्य किए थे। यह साक्षी स्वीकार किए हैं कि पर्चा प्रदर्श A3, A4, A5 उनके द्वारा बनाया हुआ, बाकी पर्चा अन्य कर्मचारी का बना हुआ। यह साक्षी आगे कथन किए हैं कि विवादास्पद भूमि की बंदोबस्ती 12 व्यक्तियों के नाम से हुई थी, जिसकी संपुष्टि उपसमाहर्ता भूमि सुधार हजारीबाग द्वारा किया गया था और बंदोबस्ती के अनुसार उन व्यक्तियों को उनका कब्जा दखल भी दिया गया था। इस साक्षी के प्रमाणित करने का बंदोबस्ती पर्चा की प्रति को वर्तमान वाद में प्रदर्श C अंकित किया गया है। यह साक्षी अपने प्रतिपरीक्षण में स्वीकार किए हैं कि विवादास्पद भूमि के संबंध में उन्होंने जानकारी 1972 में हुई तथा उससे संबंधित बंदोबस्ती का पर्चा, नक्शा, बंदोबस्ती का प्रस्ताव एवं चेक स्लिप वे स्वयं ही बनाए थे एवं बंदोबस्ती से संबंध में उससे संबंधित रैयती 2 का अवलोकन किए थे। इसके अनुसार बंदोबस्ती का प्रस्ताव वे अंचलाधिकारी के आदेश से बनाए थे। स्पष्ट है कि यह साक्षी भी प्रतिवादियों के बाद के तथ्यों का एक स्वर में समर्थन किया है। मेरी समझ में knowingly lordship it has not been indicated that he has deposed on behalf of the defendant number 1 to 14, not on behalf of the state, and that is my categorical stand. Now, Lordship, page 14. Some exhibits have been discussed, Lordship. राइट को जो देख लीजिए उसमें है सारा लंबा है, देख लीजिए इसको। वादी की तरफ से दीवानी प्रक्रिया संहिता के धारा 80 के अंतर्गत प्रतिवादी 15 से 18 को दी गई नोटिस की प्रति अभिलेख पर लाया गया है, जिसे वर्तमान वाद में प्रदर्श अंकित किया गया है। यहीं पर वर्णन करना समझता हूँ कि प्रतिवादी की विद्वान अधिवक्ता की दलील थी प्रदर्श 1 न वैध था और न वैध तरीके से प्रतिवादी को दिया गया था। इसके साथ ही इससे संबंधित पत्रालय की रसीद है, जिसे वर्तमान वाद में प्रदर्श 8 से लेकर 8C अंकित कराया गया है। इसके माध्यम से नोटिस भेजने की बात कही है, मगर प्रतिवादियों की विद्वान अधिवक्ता प्रदर्श 1 एवं 8 से इसकी अवैधता के संबंध में कोई तर्क प्रस्तुत नहीं कर सके और न इस संबंध में कोई प्रावधान दिखा सके। अतः मात्र इसे वैध कह देने से अवैध कह देने से अवैध नहीं माना जा सकता। वादी की तरफ से शिवशंकर प्रसाद अमीन द्वारा विवादास्पद भूमि को मौके पर की गई नापी से खंडों को विभाजित करने के संबंधित प्रतिवेदन अभिलेख पर लाया गया है, जिसे वर्तमान वाद में प्रदर्श 2 अंकित किया गया है। जहाँ तक प्रदर्श 2 का प्रश्न है, उस पर कोई भी तिथि अंकित नहीं है और न वर्ष अंकित है, न स्वयं अपने बात इसका इम्पोर्टेंट नहीं है। उसके बाद हम अतः प्रतिवादियों के विद्वान अधिवक्ता उस दलील काफी बल है कि बिना किसी प्रयोजन के वादी की तरफ से तैयार किए गए इस तरह के संदेहास्पद प्रतिवेदन का महत्व नहीं दिखाना चाहिए। साथ ही वादी की विद्वान अधिवक्ता इसकी उपयोगिता एवं महत्ता के संबंध में न्यायालय के समक्ष साक्ष्य प्रस्तुत करेंगे। इसी तरह से इसमें संबंधित नक्शा का भी कोई महत्व नहीं। नाउ लॉर्डशिप, इट इज अबाउट एग्जिबिट C6। इसी तरह बीट अफसर बड़का गांव, इसको अपडेट कोर्ट जरूर डील किए कि यहाँ पे इसको इतना ही करके छोड़ दिए, बट अपडेट कोर्ट हैज डेल्ट विद दिस। इसी तरह बीट अफसर बड़का गांव द्वारा दिए गए प्रमाण पत्र दिनांक 4/6/1974 पर बीट अफसर महेंद्र लाल के हस्ताक्षर के साथ साथ खाता संख्या 59 से संबंधित खतियान की सत्यापित प्रतिलिपि का वर्तमान वाद के संबंध में कोई मत नहीं। इस खाता नंबर 59 लॉर्डशिप इज एग्जिबिट 10 that was our ancestral land। ये कहते हैं कि एग्जिबिट 6 भी बीट अफसर का कुछ कोई महत्व का नहीं है और एग्जिबिट 10 भी कोई महत्व का नहीं है।
Exhibit 6 he says is related to खाता number 59।
नहीं, वो 59 का दूसरा उसका एग्जिबिट नहीं लिखे, दैट इज एग्जिबिट 10। फिर से पढ़ा जाए, फिर से पढ़ लें। उसी तरह बीट अफसर बड़का गांव द्वारा दिया गया प्रमाण पत्र दिनांक 4/6/74 पर बीट अफसर महेंद्र लाल के हस्ताक्षर के साथ साथ वहां खत्म होगा के साथ साथ खाता संख्या 59 से संबंधित खतियान की छायाप्रति, ये खतियान की छायाप्रति 59 का हम दाखिल किए हैं, we had filed that is exhibit 10।
जैसा
हाँ, प्रतिलिपि का वर्तमान वाद के संबंध में कोई महत्व नहीं। जैसा कि ऊपर कहा जा चुका है कि बीट अफसर के हस्ताक्षर को प्रदर्श 6 अंकित किया गया है एवं ग्राम पकरी बरवाड़ी के खाता संख्या 59 की सत्यापित प्रतिलिपि को प्रदर्श द अंकित किया गया 10 अंकित। दिस व्हाट आई एक्सपेक्ट। मगर वादी के विद्वान अधिवक्ता प्रदर्श 6 एवं 10 की न कोई उपयोगिता के संबंध में कोई दलील प्रस्तुत कर सके और न ही विवाद के संबंध में इसकी गुणवत्ता स्पष्ट कर सके। Only on this ground that the advocate could not explain why Exhibit 6 and Exhibit 10 is being produced, and therefore this has been dismissed. अतः मेरी समस्या प्रदर्श 6 एवं 10 का कोई महत्व नहीं है, मगर वादी की तरफ से दाखिल फर्द रिपोर्ट अमीन बाबत पैमानिश रामगढ़ राजा द्वारा निर्गत एक लगान रसीद, बिहार सरकार द्वारा निर्गत 3 लगान रसीद एवं कथित हुक्मनामा अभियान 20-12-42 को बहुत अधिक महत्व है, जिसे वर्तमान बाद में क्रमशः प्रदर्श 3, 4, 5, 6, 7 एवं 10 7 अंकित किया गया है। अतः इन कागजातों को आगे वर्णन किया जाएगा। ड्राफ्टर लॉर्डशिप या हम लोग नीचे आते हैं। Now para 10 at page 16. These are the exhibits by 9 to 12. प्रतिवादियों की तरफ से बिहार प्रतिवादियों की तरफ से बिहार सरकार के द्वारा प्रतिवादी संख्या 1 से 14 तक पक्ष में विवादास्पद भूमि की बंदोबस्ती से संबंधित पर्चा एवं उससे संबंधित नक्शा को अभिलेख पर लाया गया है, जिसे वर्तमान प्रदर्श A से लेकर A7 तक अंकित किया गया है एवं विवादास्पद भूमि से संबंधित प्रतिवादियों के नाम से बिहार सरकार द्वारा निर्गत लगान की रसीदों को अभिलेख पर लाया गया है, जिसे वर्तमान बाद में प्रदर्श B से लेकर B25 तक अंकित किया गया है। इसी तरह बंदोबस्ती पंजी की छायाप्रति अभिलेख पर लाई गई है, जिसे वर्तमान बाद में प्रदर्श C अंकित किया गया है एवं विद्वान अपर समाहर्ता हजारीबाग के न्यायालय से संबंधित वाद संख्या एमआर नंबर इतना पारित आदेश दिनांक 4/6/86 इस सत्यापन प्रतिलिपि दाखिल की है, जिसे वर्तमान में प्रदर्श G अंकित किया गया है। जैसा कि यह कहा गया है, इन्हीं कागजातों के आधार पर प्रतिवादी संख्या 1 से लेकर 14 तक विवादास्पद भूमि पर अपना दावा रखते हैं। प्रदर्श A से लेकर A7 एवं B से लेकर B25 की आलोकन से ज्ञात होता है कि विवादास्पद भूमि की बंदोबस्ती बिहार सरकार द्वारा संबंधित प्रतिवादियों के नाम से सरकारी प्रक्रियाओं का अनुपालन करते हुए किया गया है। उनके कब्जा पर उनके नाम में लगान एवं रसीद को निर्गत किया गया और प्रतिवादी गण उनका भुगतान करते आ रहे हैं। यह भी वादी के इस बंदोबस्ती के खिलाफ विद्यमान अंचलाधिकारी से लेकर विद्यमान आयुक्त उत्तरी चोटनागपुर हजारीबाग के न्यायालय में संघर्ष किए, मगर उस संघर्ष में उनकी पराजय हुई। प्रतिवादी संख्या 1 से 14 तक इन पक्षों में अन्य प्रतिवादियों द्वारा की गई बंदोबस्ती को वैध ठहराया गया, जिससे असंतुष्ट होकर वादी वर्तमान बात दाखिल किए हैं। प्रतिवादियों की तरफ से अन्य कोई कागजात दाखिल नहीं किए गए हैं। अतः उक्त वर्णित मौखिक एवं कागजी साक्ष्यों के साथ साथ उभय पक्षों की तरफ से लाए गए वाद के तथ्यों के संबंध में पक्षकारों की तरफ से दी गई दलीलों के संक्षेप में वर्णन करना आवश्यक है। जैसा कि वर्णन किया जा चुका है, वादी का विवादास्पद भूमि का दावा हुक्मनामा इतना के साथ साथ भूतपूर्व जमींदार द्वारा निर्गत लगान रसीदों पर आधारित है, जिसे वर्तमान बाद में क्रमशः प्रदर्श 7 एवं 4 अंकित किया गया है। इसके साथ ही प्रदर्श 3 का भी काफी महत्व दिखाया गया है। इन 3 कागजातों के साथ साथ स्वयं बिहार सरकार द्वारा निर्गत लगान रसीद, जिसे वर्तमान बाद में प्रदर्श 5 से लेकर 5 इतना अंकित किया गया है, के आधार पर स्वत अधिकार एवं की घोषणा के साथ साथ उनके कब्जा की संतुष्टि के घोषणा की मांग की गई है और वादी के विद्वान अधिवक्ता दलील थी कि इन तीनों कागजातों को वाद के अनुकूल एक आकार साक्ष्य है। अतः डिग्री पारित की जानी चाहिए, मगर प्रतिवादियों के विद्वान दलील थी कि जाली एवं बनावटी होने के साथ साथ वादी का खूब रचित कागजात है, जिसे पुराने कागज पर नई स्याही एवं पेंसिल से विवादास्पद भूमि को हड़पने के उद्देश्य से तैयार किया गया है। साथ ही प्रदर्श 4 एवं प्रदर्श 3 में खूब रचित लगान रसीद है एवं फर्द रिपोर्ट अमीन पैमानिश है, जो पुराने कागज पर कुछ वर्ष पूर्व लिखा हुआ है। इसी कारण इस पर स्याही फैल गई है। प्रतिवादियों के अधिवक्ता के अनुसार किसी भी परिस्थितियों में इन कागजातों के आधार पर वादी के स्वत की घोषणा एवं कब्जे की संपुष्टि की घोषणा नहीं की जा सकती। इसके साथ साथ उनकी अगली दलील यह थी कि यदि प्रदर्श 7 सही में भूतपूर्व जमींदार द्वारा वैध ढंग से निर्गत किया रहता, तो इसके साथ साथ भूतपूर्व जमींदार द्वारा वादी के पिता के नाम लगान की रसीद निर्गत की गई रहती, मगर ऐसा सत्य नहीं है। जहां तक प्रदर्श 4 का प्रश्न है, दिनांक 15/2/42 को कहा गया कि जैसा कि इस पर लिखा हुआ है, वादी के विद्वान अधिवक्ता प्रतिवादी की तरफ से प्रस्तुत की गई दलील के संबंध में कोई ठोस एवं युक्ति संगत दलील प्रस्तुत नहीं कर सके, जिसके आधार पर प्रदर्श 3, 4 एवं 7 की विश्वसनीयता को स्वीकारा जाए, क्योंकि हुक्मनामा प्रदर्श 7 को नंगी आंखों से देखने से यही लगता है कि पुराने छपे हुए कागज पर कुछ समय पूर्व इस पर लाल रोशनाई एवं पेंसिल से लिखावट किया गया है और लाल रोशनाई से पुराने कागज पर लिखे जाने से फैल गई, जिसकी लिखावट लगभग अपठनीय होती जा रही है। प्रदर्श 7 को देखने से भी स्पष्ट है कि प्रबंधन के रूप में किए गए हस्ताक्षर एवं उसके साथ दी गई तिथि, साथ ही साथ इस पर संख्या की तिथि किसी भी स्थिति में दिनांक 20/12/42 की नहीं हो सकती। साथ ही ऐसा कि प्रतिवादियों के विद्वान अधिवक्ता द्वारा दलील दी गई प्रदर्श 7 के बरहर क्षेत्रफल वाले भाग में जानबूझकर वादी द्वारा काली रोशनाई डालकर उसे कुछ फैला दिया गया है, जिससे स्पष्ट है कि वादी अपने किए गए अपराध को छिपाने का प्रयास किए हैं। स्थिति जो भी हो, प्रदर्श 7 का अस्तित्व कभी भी 1942 का नहीं हो सकता, क्योंकि उस पर के लिखावट एवं हस्ताक्षर बहुत बाद के क्योंकि उस पर के लिखावट एवं हस्ताक्षर बहुत बात की है। जहां तक प्रदर्श 3 का प्रश्न है, इसके अवलोकन से भी स्पष्ट होता है कि पुराने कागज पर कुछ वर्ष पूर्व की गई रोशनाई से इससे लिखाकर इसे तैयार किया गया है। इसका समर्थन इससे भी होता है कि कथित अमीन द्वारा दिनांक 15/3/42 को विवादास्पद भूमि की नफी की गई थी और सत्यापित प्रतिलिपि रामगढ़ राज से दिनांक 22/2/42 को निर्गत की गई। Now here Lordship, I'll pause. Here what the learned trial court wants to say, that this Amin report, which is on which basis Lordship the hukamnama was granted, was dated 15/3/1942, but the certified copy of the document, which is dated 15/3/1942, was obtained on 22/2/1942। मतलब इनका कहना है कि डॉक्यूमेंट बनने के पहले वो सर्टिफाइड कॉपी कैसे आ गया, उसका डेट 22/2/42 कैसे वहां पे। So that is a document, Lordship, very important. Go to Lordship, you may see that document, because I have the certified copy from the Lordship's court. इसको जरूर देखेंगे अगर, और इसी बेसिस पे कहा गया कि ये ऑब्टेन्ड है, समहाउ फॉल्सली ऑब्टेन्ड, और सर्टिफाइड कॉपी आपको 22/2/42 का है। एक्चुअली इट इज लॉर्डशिप 22/12/42, दैट इज रिक्वायर्ड टू बी सीन। वादी के विद्वान अधिवक्ता की इन दोनों तिथियों की असंगतता के में उनके आपस में विरोधाभास के संबंध में कोई दलील एवं तथ्य प्रस्तुत नहीं कर सकते, जिसके आलोक में इन्हें असंगत नहीं कहा जा सकता एवं एक दूसरे के विरोधात्मक नहीं कहा जा सकता, क्योंकि प्रदर्श 3 के मूल अस्तित्व दिनांक 15/3/42 को हुआ, तो इसकी सत्यापित प्रतिलिपि करीब 1 माह पूर्व यानी दिनांक 22/2/42 को निर्गत होने का औचित्य नजर नहीं आता, क्योंकि कोई भी सत्यापित प्रतिलिपि दिनांक 15/3/42 के बाद ही मिलने की संभावना हो सकती है। जहां तक प्रदर्श 4 जो भूतपूर्व जमींदार द्वारा लगान रसीद का निर्गत करने का तथ्य है, प्रदर्श 3 एवं 7 के अवलोकन से इस पर भी विश्वास नहीं किया जा सकता। ओनली ऑन द ग्राउंड दैट 3 को हम डिसबिलीव किए, 7 को हम डिसबिलीव किए, एंड देयरफॉर 4 इज आल्सो डिसबिलीव, क्योंकि उक्त वर्णित साक्ष्यों एवं तथ्यों के आलोक में प्रदर्श 3, 4 एवं 7 किसी भी परिस्थिति में विश्वास के योग्य नहीं है और न स्वयं वादी के तरफ से परीक्षित वादी एवं उनके साक्ष्यों के कथन के संबंध में विश्वास करने लायक, क्योंकि वादी की तरफ से कोई भी साक्ष्य सन 1942 के संदर्भ में सक्षम साक्षी नहीं है और जो भी साक्षी उनके तरफ से परीक्षित हुए हैं वे स्वतंत्र साक्षी नहीं रहते, जैसा कि उनके कथन एवं प्रतिवादियों की तरफ से प्रस्तुत की गई दलीलों से ज्ञात होता है। मगर इन संबंध एवं प्रतिवादियों की तरफ से परीक्षित साक्षियों के साक्ष्य काफी ठोस एवं महत्वपूर्ण है। जहां तक प्रदर्श 5, 5A एवं 5B, दिस इज लॉर्ड्स ऑफ द गवर्नमेंट रेंट रिसिप्ट। 5 एवं 5B का प्रश्न है, इन रसीदों में 5A एवं 5B अस्पष्ट रूप से पढ़ने योग्य नहीं रह गए हैं। प्रदर्श 5 पढ़ने योग्य है। इस संबंध में वादी के विद्वान अधिवक्ता की दलील थी कि भूतपूर्व जमींदार की जमींदारी समाप्त होने के बाद भी वादी एवं वादी के पिता को विवादास्पद भूमि के संबंध में बिहार सरकार द्वारा रैयत करार देते हुए वादी के पिता के नाम में ये लगान की रसीद निर्गत की गई है, जिसे वादी को विवादास्पद भूमि पर स्वत अधिकार एवं कब्जे में समर्थन होता है। मगर प्रतिवादियों के विद्वान अधिवक्ता की दलील थी कि प्रदर्श 3, 7, 3 एवं 4 ही विश्वास योग्य नहीं है, तो प्रदर्श 5 सीरीज के आधार पर वादी के स्वत की घोषणा नहीं की जा सकती। नाउ दिस इज आल्सो बीन प्रश्न। इसके साथ ही प्रतिवादियों की तरफ से भी यह दलील दी गई कि प्रदर्श 5 सीरीज की रसीद संबंधित कर्मचारियों द्वारा गलती से जाली कागजात के आधार पर निर्गत कर दी गई थी, जिसके संबंध में सही स्थिति की जानकारी होने पर स्वयं उस कर्मचारी, इज आल्सो इम्पोर्टेंट, स्वयं उस कर्मचारी एवं पदाधिकारियों के द्वारा उसे रद्द कर दिया, क्योंकि वादी के पिता के नाम से इन रसीदों को निर्गत करने के संबंध में किसी सक्षम पदाधिकारियों का कोई आदेश नहीं था। साथ ही उनका यह भी दलील थी कि यदि वादी के तथ्य सही रहते तो उन्हें भूतपूर्व जमींदार द्वारा निर्गत और भी लगान रसीदें रहती और बिहार सरकार द्वारा
रिटर्न या वो ऑर्डर ऑफ असेसमेंट ये सब कुछ भी फाइल
नहीं, असेसमेंट चूंकि इट वाज ऑलरेडी असेस्ड 3 and 4, 5 and 6 of BRR Act will not apply। जमीन एसेस था, हम लगान रसीद देते थे, जब वो वेस्ट हुआ तो ऑटोमेटिक हमारे
जमींदार के रिटर्न में होगा ना,
वो सब तो फाइल, दैट इज नॉट फाइल,
there is no order also,
nothing is there,
only the rent receipts are there,
rent receipts of the jamindar and as well as by the state, and it is
but you see the rent receipt of the state is followed by an order, isn't it?
वो उसके डीसीएलआर के ऑर्डर, नहीं डीसीएलआर के ऑर्डर में आया है, वही आया है कि 1970 में हमने,
you see that order वो प्राइमरी एविडेंस नहीं है ना,
हाँ वो तो
तो
बहुत सारी चीज नहीं आया
उसमें बहुत सारी चीजें लिखी होंगी,
इसमें
आपके चीज में जो चीज लिखा हुआ है आपके फेवर में उसको हम सिलेक्टिवली कैसे उसको,
हाँ जो रिकॉर्ड बनी उस पर तो हम नहीं बोलेंगे, लेकिन हम इंडिकेट कर सकते हैं वहां से एग्जिबिट डी से कि उसमें वो डीसीएलआर लिखते हैं कि इनके नाम से 1970 में खुल गया था और इसको 1984 में कैंसिल कर दिया यूनिलैटरली on the instruction of the कर्मचारी, from there the cause of action is, वो उस पे लिखे हुए, that is exhibit D, I can have a reference from that, but that order of the opening of the जमाबंदी is not there। हाँ साथ ही उनको यह भी दलील थी कि यह वादी के बाद भी तथ्य सही रहते तो उन्हें भूतपूर्व जमींदार द्वारा निर्गत और भी लगान रसीदें रहती एवं बिहार सरकार द्वारा भी लगान रसीद रहती, मगर ऐसा नहीं रहने के कारण यह भी लगता है कि सभी लगान रसीदें जाली और साथ ही साथ सभी रसीद विदाउट प्रोड्यूस हैं। वादी के विद्वान अधिवक्ता प्रतिवादी के तरफ से यह भी प्रस्तुत की गई दलीलों के संबंध में कोई ठोस तथ्य दलील प्रस्तुत नहीं कर सके, अतः मैं उक्त वर्णित वर्तमान वाद के तथ्यों के साक्ष्यों के आलोक में बिना हिचक के निष्कर्ष पर पहुंचने के लिए बाध्य होता हूँ कि वादी की तरफ से दाखिल किए गए कागजात सभी कागजात विश्वसनीय नहीं है और इनके आधार पर विवादास्पद भूमि पर उनके स्वत अधिकार की घोषणा नहीं की जा सकती और कहीं उनके कथित काल्पनिक कब्जे को संपुष्टि किया जा सकता है। जहाँ तक प्रतिवादियों की तरफ से दाखिल कागजातों का प्रश्न है, प्रदर्श ए सीरीज, बी सीरीज, सी सीरीज और डी सीरीज का स्पष्ट है कि विवादास्पद भूमि जमींदारी समाप्त होने के बाद बिहार सरकार में सम्मिलित हुई थी, जिस पर 10 वर्षों तक जियोलॉजिकल सर्वे ऑफ इंडिया का कैंप था और कैंप की समाप्ति के बाद वन विभाग द्वारा उनके कुछ हिस्से पर वन लगाया गया और विवादास्पद भूमि पर बंदोबस्ती भूमिहीन हरिजनों के नाम नापी एवं स्थानीय जांच के बाद की गई, जो वर्तमान वाद में प्रतिवादी संख्या 1 से 14 तक है। वादी के विद्वान अधिवक्ता प्रतिवादियों की तरफ से दाखिल इन कागजातों की विश्वसनीयता के संबंध में संदेह प्रकट करने का कोई कारण एवं आधार प्रस्तुत नहीं कर सके। प्रतिवादी संख्या 1 से 14 तक सभी साक्षियों उन कथनों के नजरअंदाज किया जाए तो सभी प्रतिवादी 15 से 18 तक साक्षी नागेश्वर प्रसाद सिंह एक स्वतंत्र साक्षी हैं, जिन्हें वर्तमान वाद में पक्षकारों से कोई संबंध नहीं है एवं उनके कथन एवं प्रतिवादियों की तरफ से दाखिल कागजातों से स्पष्ट है कि संबंधित विवादास्पद भूमि बिहार सरकार की थी, जिसे प्रतिवादी संख्या 1 से 14 के पक्ष में विधिवत बंदोबस्ती कर दी गई। हालांकि प्रतिवादी संख्या 1 से 14 तक की तरफ से जिस भी साक्षी का परीक्षण कराया गया, उनके कथन स्वतंत्र एवं विश्वसनीय एवं प्रतिवादियों की तरफ से दाखिल कागजातों के अनुकूल। अतः मैं बिना हिचक इस निष्कर्ष पर पहुंचता हूं कि प्रतिवादियों की तरफ से परीक्षित साक्षियों एवं कथन एवं उनके तरफ से दाखिल उक्त कागजात काफी विश्वसनीय एवं ठोस है, जिसे अस्वीकारने का अभिलेख पर कोई कारण एवं आधार नहीं है। प्रतिवादियों के विद्वान अधिवक्ता की अगली दलील थी कि स्वयं वादी एवं उनके साक्ष्यों के कथन के साथ साथ प्रतिवादियों की तरफ से प्रस्तुत किए गए साक्ष्यों एवं कथन के स्पष्ट है कि प्रतिवादी भूमि पर सन 1975 से पूर्व 10 वर्षों तक जियोलॉजिकल सर्वे ऑफ इंडिया का काम था और उस विभाग के पदाधिकारियों का निवास एवं उनकी गाड़ी एवं मशीनों को रख रखाव की विवादास्पद भूमि पर व्यवस्था की गई थी। अतः ऐसी स्थिति में वादी के बाद में यह तथ्य संदेहजनक हो जाते हैं कि जिनके द्वारा कहा गया है कि विवादास्पद भूमि पर सन 1942 से लेकर अब तक वादी और उनके पिता बिना किसी व्यवधान की खेती करते आ रहे थे। अतः इस आरोप में भी वादी के बाद से इन तथ्यों के साथ साथ उनके तरफ से दाखिल सभी कागजात अपडेट कोर्ट में आते हैं। Page 17 and para 17.
Page 17.
No, of the update. I think running page 15. It is submitted on behalf of the plaintiff, update that he has acquired a disputed land by Gumnama such and such. So, pardon me. Internal page 17 से 4-5
17
1 7
ना पेज
ऊपर ही लिखा
नहीं पेज 10 पर
अच्छा टाइप
16 then I have 13
अच्छा
ऊपर 13 लिखा हुआ है 17 है क्या
पेज 26
पैरा 14 बताइए इज इट पैरा 14
पैरा 7 पेज 26 में लगता है ये वाला पेज 24 पेज 24 और पैरा 17 मिल गया
हाँ पैरा 17
हाँ ये पेज 24 पे हुजूर
हाँ
हाँ इससे हम बताएंगे दो चुकी मेरे पास दो It is submitted on behalf of the plaintiff, appellant, that he has acquired the disputed land by way of Gumnama dated such and such granted by the ex-landlord, and in course of settlement, the ex-landlord has measured the disputed land, and the rent receipts were granted to him by the Ramgarh Raj, and thereafter the rent receipts were also granted by the government of Bihar, which has been proved in this case marked as exhibit 7, 3, 4 and 5, 4 to 5, 5 to 5 respectively. It is submitted by the plaintiff appellant at the lower appellate court. The lower court has not relied upon the aforesaid exhibits on which the lower court has wrongly decided the aforesaid appellant, stating that these documents were forged and fabricated, manufactured by the plaintiff. The plaintiff appellant had made the claim upon the disputed land based upon Hukumnama dated 20/12/42 along with the rent receipts granted by the ex-landlord marked Exhibits 7 and 4 respectively. The plaintiffs have also made claim upon the basis of Exhibit 3, which is measurement report of Amin of ex-landlord as well as the rent receipt granted by the government of Bihar, which is Exhibit 5 to 5B, upon which the plaintiff has claimed the declaration of right title in possession of the disputed land and also for the confirmation of possession of the disputed land. The land counsel of the plaintiff appellant has given much stress upon the claim of the plaintiff based on the requested documents, while the land counsel of the respondent defendant had argued that the claim of the plaintiff based on the Hukumnama dated 20/42 Exhibit 7 is totally false fabricated, which was manufactured by the plaintiff on the old paper by making endorsement through the red ink and pencil only with a view to grab the disputed land. The land counsel for the defendant respondent had also made stress on the genuinity of Exhibit 4 and 3 by way of plaintiff made claim that the Exhibit 3 and 4, which is rent receipts and the amendment made on older paper some years ago, which was manufactured by the plaintiff in collusion with the Amals of the Ramgarh branch. In course of the acknowledgement advanced on behalf of the respondent, the land counsel had argued that in no case the title of the plaintiff be declared in this paper as well as the position of the confirmation was also not made in favor of the plaintiff. In course of argument advanced on behalf of the respondent defendant, the land counsel had submitted that the Exhibit 7 Hukumnama was illegally granted by the ex-landlord. In that case, there must have been illegally granted by the ex-landlord. In that case, there must have been the rent receipt issued in the name of the father of the plaintiff. It is in the father of the plaintiff. The rent receipt has been granted. That is Exhibit 4, Lordship. That is in the father of the
These are all
plaintiff.
submissions. इसका क्या मतलब?
हाँ, नहीं उसको आगे उसको accept कर ली. Father of the plaintiff by the ex-landlord, but the rent receipt were not granted in favor of the father of the plaintiff, and as such, the claim of the plaintiff be declared to declare title in his favor as well as the confirmation of his position is totally false and baseless. So far as the question 4 of Exhibit 4 is concerned, it is said to be dated 15/2/1945, written on the exhibit, but the argument advanced on behalf of the defendant respondent about the genuineness of the document. The land counsel has not made any plausible argument to this fact. The land counsel for the plaintiff appellant has also not advanced any plausible and believable argument upon the genuinity of Exhibit 3, 4, and 7, for which the plausible and believable argument was made by the independent respondent counsel on the plain perusal of the Hukumnama. It appears that the endorsement by the red ink and pencil was made on that document and old paper some times ago, and as such the endorsement made by the red ink on old paper spread over the which makes the document unreadable. Translation of the trial court judgment or kuch bhi nahi. On perusal of the Exhibit 7, it becomes clear that the signature along with the date and the number written on that Exhibit 7 dated 20/42 makes it clear that the date, signature and number was not dated 20/42. The defense counsel in course of the argument pointed out that the plaintiff had knowingly put ink upon Exhibit 7, writing in black ink, and by making spread over the writing, which makes it clear that the plaintiff has tried to conceal his doing upon Exhibit 7. On plain perusal of Exhibit 7, it appears that the exhibit has not come in existence in the year 1942. It has become crystal clear from the writing of the signature made upon the exhibit later on. So far, the question of Exhibit 3, on its perusal, it clearly appears that the endorsement by the new ink some years ago was made, and the old document and get it prepared, which becomes corroborated by the assertion of the Amin by the said Amin who had measured the disputed plot on 15/3/1942, and certified copy of the said document was issued from Ramgarh Raj on 42/2/1942. This also again not the same thing is being read. The land counsel of the plaintiff appellant had not advanced any correct and plausible argument of the disputed claim with regard to two dates. The original Exhibit 3 had come into existence on 15/3/42 and its certified copy was issued on 22/42, about 1 month prior to that. So the question of issuing the certified copy prior to the original came into existence has not got any possible ground at first, and the original will be granted for the copy which will be issued later on. So far, the question of Exhibit 4, which is a rent receipt granted in favor of the plaintiff by the ex-landlord, it cannot be believed in view of the discussion made with regard to Exhibit 3 and 7, as the discussion made ever was in respect to Exhibit 3, 4, and 7, and no case it is believable, and the evidence of the plaintiff and his witness on the said point are also not believable, as none of the witnesses of the plaintiff are competent to corroborate the fact of 1942, as none of the plaintiffs are independent witnesses, whereas the claim of the argument made on behalf of the respondent defendant and the witnesses deposed on behalf of the defendant. The evidence of the statement of the witnesses of the document are material and on which corroborates the defendant's claim over the disputed part. So far as Exhibit 5, 5 and 5B is concerned, the receipt, which is Exhibit 5A and 5B, is not readable, and Exhibit 5 is only perused. On this point, the learned counsel on behalf of the plaintiff argued that after vesting of the Jamindari ex-landlord, the plaintiff was recognized as recorded tenant of the disputed land by the Bihar government, and the rent receipt were issued in favor of the father of the plaintiff, on which basis the plaintiff has the right title and possession over the disputed plot, which corroborates the right title and interest and possession upon the disputed plot of the plaintiff. Whereas the learned counsel for the defendant respondent argued that Exhibit 7, 3, and 4 cannot be displeased, then there is no question of declaration of title be declared in favor of the plaintiff on the basis of Exhibit 5 series. It is also argued by him that Exhibit 5 series were wrongly granted by the said Karmachari on forged documents, and when the true fact became clear, in the said Karmachari of the officer, the rent receipt granted government by government was cancelled, as there was no order of the competent authority with respect to granting of the receipt. It has also been argued on behalf of the defendant respondent counsel that in fact, if the fact of the case of the plaintiff is true, then there must be other rent receipt which were continuously granted by the ex-landlord and by the state of Bihar. But the case of the plaintiff is not of the said fact, so it appears that all the rent receipts of the plaintiffs are forged. The learned counsel of the plaintiff had not in any concrete argument advanced on behalf of the defendant respondent counsel with regard to the said fact. The lower court had rightly decided the said fact and issue of the issue issued by coming into the conclusion on the basis of the evidence of the fact in the case of the document which are exhibited filed on behalf of the plaintiff appellant are not believable, on which basis the right and title shall be declared in favor of the plaintiff on the disputed plot. The lower court has also correctly come to the conclusion that only artificial and imaginary position of the plaintiff can be ascertained only. So far as the document filed on behalf of the defendant's respondent, which is Exhibit A series, B series, C series, D series, it becomes clear that after vesting of the Jamindari, a disputed plot was vested into the ownership of the state of Bihar, on which about 10 years there was Geological Survey of India camp was set up, and after completion of the work of the camp, the forest department has planted forest upon some portion of the land, and after measurement of the local inspection made by the government authorities, the disputed land was settled by the state government in favor of the landless Harishans, who are a defendant number 1 to 14 of this case. The plaintiff advocate had not placed any reason on ground to disbelieve the genuineness of a document filed on behalf of the defendant. DW8 Nageshwar Prasad Singh is an independent witness who has no concern with the parties of the case, and on the basis of the statement of the witness and on the basis of the document filed on behalf of the defendant, it becomes clear that the said disputed clause for in possession of the state of Bihar, which was legally settled in favor of defendant number 1 to 14. The evidence of the defendant's witness is independent, believable, and corroborative. The lower court has rightly. It is further submitted on behalf of the defendant respondent that it becomes clear that from the evidence of the plaintiff, this witness is also the fact that the defense, the evidence stated by the respondent defendant that there was a geological survey in India camp which was set up in the disputed plot. There was to 1975 till 10 years, and the course of working of the camp, the department officer residence there was there, and for the purpose of keeping vehicle and the machinery such and such. So contention of the plaintiff that since 1942, he along with his father and coming into peaceful possession of the disputed plot became lawful, and that due to whose documents, Hukamnama and implicit legitimate report of the plaintiff are also become doubtful that the learned plaintiff Apparent counsel has failed to advance any believable argument on this fact, whereas the course of submission he has submitted the Geological Survey of India Department has not taken the disputed plot on right or pata in any way. So it becomes clear that the plaintiff apparent is never in possession of a disputed land, but they were Geological Survey of India map over a disputed plot for several years, and in course of working on the camp on disputed plot, it was not possible for cultivating the land. Now, paragraph 19. Under the facts and circumstances discussed above, the examination of the evidence becomes clear that documents filed on behalf of the plaintiff apparent Hukamnama dated 20/12 measurement report dated 3 and the rent separated such and such. And 3 rent receipt issued from the Anchal Adhikari is such and such as not believable on the basis of the doubtful documents by the plaintiff right that the interest over a disputed land cannot be declared, nor his position be confirmed over the said disputed land, and the plaintiff is also not entitled to any such as such.
Yes, what do you have to say?
अब एक एग्जिबिट डी हुजूर हम उसको पास पढ़ना चाहेंगे.
Exhibit B.
हाँ, डी. The order of the AC option. 4/6/1986. A miscellaneous revenue revision was filed in this court on 26/3/1984 against the order of the learned LRDC seller passed in case number 22 of 82, dated 18/11/1982. The petitioner was duly heard and finding for any interference with the order of the learned LRDC, so that the petition was rejected at admission stage in miscellaneous revision case number 11 of 84 on 28/5/1984. Against this order, the revision petition was filed in the court of learned Commissioner of Jharkhand, which was pleased to remand the case for fresh hearing and disposal. Only observation of the learned Commissioner North Chhatnagpur Division while remanding the case was that the area involved was not clear in the order passed by this order on 28/5/1984. Accordingly, this miscellaneous revision was once again taken on 13/8/1984, and the case was finally heard on 16/12/85. At that time of hearing
I don't wish to say 45 में आपका singular rent
45 में
singular rent dispute है.
हाँ singular dispute.
उसके बाद आपका कोई भी जनरेट वेस्ट का हुआ 56 जमाबंदी अकॉर्डिंग टू कब
1970 वही हम इसमें दिखाना चाहते हैं।
इस बीच क्या हुआ
पोजीशन में क्यों हुजूर बड़ा चंक ऑफ लैंड है, मेनी लैंड्स आर देयर, उतना रईयत लोग उस टाइम पे thereafter the जमाबंदी was opened.
नहीं you see there is no scope for in the nature of the substantial question of law it is not a case से doubt करके आपका case they have discussed the materials and then rejected
अच्छा
it is not a case जो substantial question of law बना है वो एक पैराग्राफ में खाली डाउटफुल लिखा हुआ है शायद उसी के आधार पे बन गया है
ने डिस्कस कुछ नहीं किया, एक ही लाइन हमेशा लिखते हैं कि the counsel of the plaintiff could not explain anything, only on that basis lordship the entire thing has been discussed.
if you are not if I put a question to you and if you are not able to explain I will write that you are not able to explain
Lordship,
will I not write that
other than that lordship even by the naked eye if lordship sees the original documents
नहीं
of
आपने अपना जो आपका प्राइमरी डॉक्यूमेंट था ओपनिंग ऑफ जमाबंदी का कोई ऑर्डर नहीं है जो आपने एग्जिबिट नहीं करा तो दैट वाज द प्राइमरी डॉक्यूमेंट इसके इस ऑर्डर के आधार पर हम आपको क्या हम आपका इस ऑर्डर के आधार पे हम क्या आपको प्रूव करना चाहिए था ना स्टेट वाज आल्सो देयर यू शुड हैव कॉल्ड अपॉन द स्टेट टू प्रोड्यूस द डॉक्यूमेंट जमींदारी रिटर्न नहीं है ठीक है क्या डिक्लेरेशन आया जमींदार
for is not.
दैट इज नॉट देयर कोई कम से कम ऑर्डर होता कि भाई इतना जमींदार का जमीन है इतना आपका जमीन है इतना वेस्ट हुआ इतना नहीं वेस्ट हुआ
Difficulty is that lordship it was settled by the Maharaja Kamakya Narayan Singh, हम लोग कहाँ से फॉर्म के लाएंगे, that is the difficulty और स्टेट तो उस पे है नहीं उस पॉइंट पे and secondly lordship the cause of action this order was the cause of action and therefore I wanted to read this order.
when this order was the cause of action then under such circumstances how do you rely upon this particular order and not bring the primary evidence on it it is not there और ये जो है आपका इसके अगेंस्ट में आपका ट्रायल कोर्ट का भी फाइंडिंग आप एपेलेट कोर्ट में भी कभी भी एडिशनल एविडेंस के लिए कभी भी कॉल फॉर रिकॉर्ड्स के लिए आपने कोई स्टेप नहीं लिया दैट वाज स्टेयरिंग एट यू राइट फ्रॉम बिगनिंग यू डिड नॉट टेक एनी स्टेप्स
एक बार इसको अगर देखेंगे ना तो सारा क्लियर हो जाएगा यही इस
नहीं ये
ऑर्डर
इसके बेसिस पे हम नहीं होल्ड कर पाएंगे ना this cannot be the basis to give a finding because this is only for the purposes of cause of action when you are seeking a declaration of title you have to prove it by
reading my own documents
by
that is
reading your own documents and bring on record the primary evidences यहाँ पे लिखा हुआ है इसलिए तो यहाँ पे तो बहुत सारा चीज लिखा हुआ है सबको सही मान लिया
नहीं हम सबको ही मान लिया जाए रजिस्टर्ड टू के बारे में हमारे फेवर में लिखा हुआ है इनका 1970 में गलत तरीके से जमाबंदी खुल गया था
you should have taken steps for the purposes of
since this is a certified copy lordship therefore that portion has to be can be considered by
No,
zoning court
how can this a portion of this
उसमें सिर्फ इतना ही लिखा है हम ठीक है हुजूर फाइंडिंग भी हमारे खिलाफ है बट जो फाइंडिंग का जो बेसिस है द बेसिस इज दैट कि 1970 में हमारा जमाबंदी खुला रजिस्टर 2 में हमारा नाम आया और रेंट रिसिप्ट कंटिन्यू हुआ इन 1984 बाय द कर्मचारी वो रेंट रिसिप्ट कैंसिल
You
की
see, the court is recording a finding that they have not brought these documents on record. Right? The order by which the Jamabandi was opened is not on record. It is very important. Return में क्या फाइल हुआ, return में क्या आया, these things are very very important. इसको हम लोग ignore नहीं कर सकते. और उसके बाद आपके जो documents हैं, उसको आप देखिएगा तो आपको हम वही देख ही रहे. आप देखते ही आपको पता लग जाएगा कि बादी का लिखा हुआ. Just have a look at it.
हम उसको एक्सप्लेन करना चाह रहे हैं
Explain क्या करना है
नहीं हम बता रहे कैसे क्या है जो चूंकि हुकुमनामा जो बनता था
हुकुमनामा का नहीं बोल रहे और भी चीजें और भी जो डॉक्यूमेंट्स हैं जिसके बारे में कोर्ट डिस्कस कर रहा है
हुकुमनामा
वो
से
पुराने कागज में जो है न्यू पेन से लिखा गया है
हम उसको खाली बता जो रेड पेंसिल की बात कर रहे हैं वो जो एग्जिबिट ये देखा जाएगा
ये
एग्जिबिट
सब चीज
7
हम लोग नहीं नो स्कोप नो देयर इज नो स्कोप इतना हम नहीं देख पाएंगे सही आप उनको मेरा पावर भी तो दिखाइए ना हमको जितना पावर है उतना ही तो देखिए हम आपका देख लिए सुन लिए अच्छे से ऐसा जो सब्सटेंशियल क्वेश्चन ऑफ लॉ बना है ऐसा नहीं है कि ये सारे डॉक्यूमेंट्स को बिना कंसीडर किए ऐसा नहीं है कि merely because it is doubtful करके दे हैव डिस्कस्ड ऑल द डॉक्यूमेंट्स and you have not produced the primary evidence. And at the same time, they have जो भी whatever was the materials placed on the corners, उसके basis
And
पे
Lordship,
judgment.
admittedly Lordship, ये सब तो हुआ था, and we also had a plea of adverse position. वो भी हमारा था उसमें.
तो दोनों चीज कैसे चलेगी?
नहीं, if it is
इशू बना था,
issue, हाँ issue बना.
उसको इशू में फाइंडिंग,
इस issue में उसमें कोई finding नहीं आया.
इस पर कोई सब्सटेंशियल क्वेश्चन ऑफ लॉ नहीं, बस क्वेश्चन तो वैसे भी नहीं बनता है, बिकॉज देयर इज अ फाइंडिंग कि 74 के पहले वो जियोलॉजिकल सर्वे ऑफ इंडिया के पास था, उसके बाद इट केम टू, तो दीस आर नॉट
इसके उसमें क्या बताएं, जियोलॉजिकल सर्वे का भी परमिशन हमसे लिया है, वो हम एग्जिबिट नहीं किए. These are the things done in the trial court. वो भी कॉपी हमारे देखने की फाइल में है. I said कि भाई why it was not exhibited of his court, and this is the order of the geological survey of India. जैसे कि बीट अफसर का मेरा वो एग्जिबिट हो गया, ये भी
अक्सर का आप देखिए ना, ऐसे चिट्ठा पे लिखा हुआ है, जैसे वो नहीं चुटका बनाते हैं. हाँ, it is not an official letter.
That is a certificate.
What certificate is this? It is not even an official letter. ना लेटर नंबर है, ना कुछ है. इस तरह से कोई लिख के दे देगा तो क्या होगा? इसका कोई रेलेवेंस है? But there has to be an official letter, a letter number. अब बीट ऑफिसर बैठ के अपना चेम्बर में बैठ के लेटर बना, ऐसा होता है? इस तरह से कोई टाइटल सूट डिसाइड हो जाएगा उसके बेसिस पे? कुछ नहीं है. चलिए सुनिए. The learned counsel for the appellant has submitted that although the zamindari returned and order by which Jamabandi was opened has not been exhibited before the learned court, but the exhibit D, which was the cause of action, and was the order arising out of proceedings relating to cancellation of rent receipt, revealed that entry was made in Register 2 and Jamabandi was opened in favor of the plaintiffs. We have submitted that this document was enough to show that the property was acquired by the father of the plaintiff in the year 1942, followed by issuance of rent receipt in the year 1945, and upon vesting of zamindari in the year 1956, the land was recorded in Register 2 in favor of the plaintiff after opening of Jamabandi. It was opened in the year 1973, followed by issuance of rent receipt by the state, which was cancelled by the state and was subject matter of consideration in the proceeding relating to cancellation of registration. During the course of hearing, it also transpired that even the register 2 was not executed, neither register 2 was executed, nor Jamindari return was filed, nor the order of opening of Jamabandi has been executed before the learned court, and admitted the Hukunnama was an unregistered document. The learned counsel pleading on behalf of the respondents on the other hand has vehemently opposed the prayer and asserted that the learned courts have not passed the order against the plaintiff on account of doubts and surmises, but the courts have passed the order after considering every materials on record and have found that the plaintiffs did not succeed in proving his case. The learned counsel has submitted that the perusal of the improved judgments in totality reveals that every aspect of the matter has been taken into consideration and the suit was dismissed. And the case was not, this suit was not dismissed merely on doubts and surmises. Submit that there is no perversity in the improved judgments, and therefore the substantial question of law be answered in favor of the respondents and against the opponents. After hearing the learned counsel for the parties, this court finds that the suit was filed by the plaintiffs seeking a declaration that they have subsisting title over Schedule A land and that the purchase granted to defendant number 1 to 14, the private defendants, did not affect their right, title and interest over the property. The plaintiff also sought a declaration that the possession of the plaintiff be confirmed, and in the alternative, if it was found that by the court that the plaintiff have been dispossessed, the plaintiff also sought a relief for recovery of possession. The suit property was in Schedule A, which belonged to Khata number 2, plot number 399, area 8.57 acres, with a given boundary. And the property was described as Grand Majulva with bracket now Rayuti, bracket closed land of Khata number 2 of village Pakri, Barwadi, PS Barkagaon, Thana number 56, district. The plaintiff claimed the property by virtue of Sada Hukunnama of the year 1942 and one written receipt staged to have been issued by the ex-zamindar in the year 1945 for 4 years from 1942 onwards. The plaintiffs claim that upon vesting of zamindari, they were found to be the rayats and Jamabandi was opened in their name, which was followed by issuance of rate receipt by the state. And rate receipts issued by the state were also exhibited before the court. The cause of action arose when settlements were made with respect to property in favor of private between number 1 to 14 and purchase were issued in their name and the revenue authority cancelled the rate receipts issued in favor of the plaintiff. There has been a number of proceedings in connection with the cancellation of rate receipt, in which the plaintiff had ultimately lost, which led to filing of the title suit and the relief has been. The state as well as the private respondents as well as the private persons in whose favor the pacha was issued, the settlement was issued, were made party in the suit. And the state as well as the private defendants, they filed their respective written statement challenging the right title, interest and possession of the plaintiff in connection with the suit. The learned trial court framed the following issues for consideration. They are appellate court के order में भी तो होगा ना English translation issues.
Same issue of the
Sorry.
trial court का जो issue है वही अपडेट कोर्ट से same
And
issue.
the same issues were
No
also
difference.
considered by the learned first appellate.
Not sure.
Para 13,
Paragraph 31, this is the update.
13
But
the issues were A, is the suit maintainable in its present form? B, Has the plaintiff got any cause of action for the suit? C. Is the suit barred by law of limitation and adverse possession? Has the plaintiff title and possession? Next, has the plaintiff title and possession over the suit land? Next, is the plaintiff entitled to get a decree as paid for? Is the to any other relief or relief to which the plaintiff is entitled? The issue in connection with the right, title, interest and possession of the plaintiff, and as to whether the plaintiff is entitled for a decree in his favor, was decided initially by the learned trial court by paragraph 5. The learned trial court has discussed the materials on record, both oral and documentary, and has recorded the following findings. इसका कुछ कुछ पोर्शन का I will translate. हमें translation देना पड़ेगा इसका तो कुछ पानी नहीं on the point of findings. The learned, upon perusal of the findings of the learned trial court, it appears that the learned trial court has threadbare considered the materials on record and have found that the plaintiff has not been able to prove his case of right, title, interest and possession with respect to personal property. The trial court has considered the inconsistencies in the materials based on record. And has come to a definite finding that documents placed by the plaintiff to assert their title were not believable. This court further finds that neither registered proof was exhibited before the court, nor the order opening Jamabandi was executed. And admittedly, the Hukumnama was an unregistered document. Even the Zamindari return was not executed before the court. And there was one solitary receipt said to have been issued by the ex-Zamindar of the year 1945 for consolidated period from 1942 to 1990. The Zamindari vested in the year 1956.
Yes, sir.
Admittedly, the Zamindari vested in the year 1956. The Learned Trial Court has considered the relevance of each of the documents exhibited by the plaintiff and had then dismissed the suit. This court is of the view that the judgment passed by the Learned Trial Court upon complete reading, which has been placed by the Learned Council during the course of hearing, reveals that it was the plaintiff who has not been able to prove his case on the basis of materials relied upon and the other material evidences which could have helped the plaintiff to prove his case were not exhibited before the court. So far as the learned first appellate court is concerned, the same points were taken into consideration. The same issues were considered, and the learned first appellate court has also considered the materials on record and upon full reading of the judgment of the learned first appellate court, which has been placed by the Learned Council for the appellant during the course of hearing. It is apparent that the plaintiff has not been able to prove their right title, interest and possession with respect to the same property. The findings of the Learned First Appellate Court, some of the extract of the finding of the Learned First Appellate Court are quoted as under. In view of the aforesaid facts and circumstances, this court is of the view that the findings of the Learned Lower Appellate Court regarding genuineness of the plaintiff's documents is not merely based on doubts and surmises, but are based on appreciation of materials on record, which has led to the documents being declared doubtful. In view of the aforesaid facts and circumstances, a substantial question of law is answered against the appellant and in favor of the respondents. This appeal is accordingly dismissed. These quotations would be there in the judgment. Nobody appears on behalf of the state. Absence reported.
Orders item 62, second to 65 of 920.
defect that was pointed out by the staff. Applicant number 2, 3, 10 and 11. Their names find mention.
There is no defect as such.
नहीं,
Defects
पैरा 8 में हम लोग लिखे हुजूर सब्स्टिट्यूशन के लिए ये पिटीशन है.
Is it for substitution?
There are 2 IM laws.
Substitution के notice हो गया?
नहीं, उसी में कुछ इसको रख दिया गया था, जोन नजूल कर दिया गया था. लास्ट ऑर्डर देख लीजिए.
आपने सब्स्टिट्यूट नहीं किया ना? Appellant number 2, 3, 10 and 11 that died.
They
You were the
died.
appellants.
Lord. So now, Lord, by this IM Lord 10380, इस IM में हम लोग प्रेयर किए कि 2 और 3 जो डेड जिनका नाम एपलेट डिग्री में आ रहा है, फर्स्ट एपलेट डिग्री में, वो डेड है, इसलिए उसको तो पार्टी हम लोग नहीं बना सकते थे. और 10 और 11 भी डेड है, इसलिए पार्टी हम लोग नहीं बनाए. Now so far 2 and 3 are concerned, for they have died not during pendency, after the judgment of the appellate.
When did they die?
Judgment is of 2018
मरे
और इन लोगों का डेट दिए हैं डेथ का, तो 18 के बाद जजमेंट के बाद इनका डेथ हुआ है.
कब? डेट नहीं, डेथ सर्टिफिकेट चाहिए. आपके हिसाब से डेट ऑफ डेट देने से थोड़ी होगा.
तो डेथ सर्टिफिकेट तो देना होगा.
तो इसका क्या मतलब है? आप दूसरी बात ये बताइए कि 2 and 3 according to you they died during the pendency of the
नहीं,
appeal.
not during pendency, after judgment of the appellate.
10 and 11 आप बोल रहे हैं.
10 और 11
After judgment.
नहीं, they died during pendency,
अभी
unmarried. लेकिन फिर भी डिलीट नहीं हुआ उन लोग का नाम या सब्स्टिट्यूट नहीं हुआ, इसलिए डिक्री में 10-11 का नाम भी आ गया, तो वो दोनों डिलीटेड वहीं से हो जाना चाहिए था. उसके लिए हम सब्स्टिट्यूट नहीं कर रहे.
अगर आप वहाँ पर पिटीशन ही नहीं फाइल करेंगे डिलीशन का, तो
हाँ.
कैसे डिलीट हो जाएगा अपने से?
हाँ, नहीं हुआ.
नहीं हुआ ना?
हाँ, नहीं हुआ.
ठीक है.
इसलिए
And
10 और-
and therefore, so far as 10 and 11 are concerned, you are responsible. तो उनका तो सब्स्टिट्यूशन का कोई
नहीं, हम लोग सब्स्टिट्यूशन नहीं मांग रहे, नहीं मांग रहे. 2 and 3 का हम लोग सब्स्टिट्यूशन देना पड़ रहा है, क्योंकि पार्टी इसलिए नहीं बना सके कि जजमेंट के बाद उनका डेथ हो गया.
कहाँ है? कौन सा आईडी है 2 and 3 का?
2 and 3 का है 10380. आइए नंबर
103
80. इसमें प्रेयर है कि एप्रिल नंबर 2 और 3 को सब्स्टिट्यूट हम लोग करने के लिए दिए. Who died after the judgment of the appellate. Appellant 2 सूरजमणि देवी died on 12/7/18 मालूम करेक्ट, और जजमेंट है वो 27/3/18 मार्च 18 का जजमेंट है. आफ्टर
Where
दैट
have you stated that they died before?
पैरा 2 में हुजूर एप्रिल नंबर 2 को लेकर बोले हैं. एप्रिल नंबर 2 सूरजमणि देवी वाइफ ऑफ so and so died on 12/7/18 after passing the judgment entitled appeal number 32/2007 by judgment date 27/3/18. और उसी तरह से फिर एप्रिल नंबर 2 का पैरा 3 में उसका एयर्स डालना, और 4 में फिर है एप्रिल नंबर 3 को लेकर.
ये
after
5 में
judgment?
क्या है? 5 में क्या है?
5 में
Deceased,
5
कौन है?
में उसी के heirs को ला दिया
नहीं 5 में the deceased विनोद लाल देवी।
वही डिसीज्ड विनोद लाल देवी, इसी का जिक्र है 4 में, पैरा 4 में।
विनोदला देवी, विनोद लाल तो नहीं लिखा है।
अब विनोदा देवी, तो उसी का heirs को ला दिए। आफ्टर जजमेंट ऑफ द एपलेट कोर्ट दे डाई। और 6 में फिर लिख दिए 10 and 11 died during pendency of the first appeal। अब वो डिलीट नहीं हुआ, वो गलती है, जो भी डिलीट हो जाता तो 10-11 का नाम एपलेट डिक्री में नहीं रहता, और उसको हम लोग को सब्स्टिट्यूट नहीं करना, डाइड एंड
तो
मैरिड।
एक सेकंड, तो इनको जो अपीला नंबर 2 और 3 को की तरफ से कौन है यहाँ पे अपीला? 2 और 3 की तरफ से कौन है?
हम ही लोग एपलेट्स सेकंड अपील जो फाइल की है,
आप कौन? What?
we are the applicants, my lord, who were applicants there also।
तो ये आपकी अपीला नंबर 2 and 3 have expired after the judgment. Who are the appellants who are representing the estate of appellant number 2 and 3?
Here तो पार्टी बन माने डेड है तो पार्टी भी नहीं बना, हम लोगों ने अपील फाइल किया।
आपने अपील फाइल किया, उनको पार्टी नहीं बनाया।
पार्टी इसलिए नहीं बनाए कि वो डेड, इसलिए नहीं बना। तो स्टैम्प रिपोर्टर अब पूछ रहा है या कह रहा है कि एपलेट डिक्री में इन लोगों का नाम है और आप लोग को क्यों नहीं एपलेट बनाए, तो उसका जवाब हम लोग दे रहे हैं कि उन लोगों का डेथ हो गया, 10 और 11 का ड्यूरिंग पेंडेंसी।
तो आप पार्टी बनाने के लिए आप पिटीशन फाइल किए हैं?
हाँ, ये 2 का 2 and 3 का
फॉर एडिशन ऑफ पार्टी,
सब्स्टिट्यूशन ऑफ 2 and
पार्टी
3।
नहीं है तो क्या सब्स्टिट्यूट?
हाँ?
भाई डेड आदमी को भी तो आप पार्टी नहीं बनाए हैं, वो तो नहीं है, आपने नहीं बनाया, तो एडिशन ऑफ पार्टी के लिए आप यहाँ अपील फाइल करेंगे, क्या करेंगे? सब्स्टिट्यूशन किसका होगा? पर्सन हु इज देयर ऑन रिकॉर्ड इज टू बी सब्स्टिट्यूटेड। It is one thing to say that the person has died after the passing of the first appellate decree and his legal heirs want to pursue this appeal. वैसा तो आपने बनाया नहीं, लीगल हेयर्स को भी आपने पार्टी नहीं बनाया है, ये बोलकर कि भाई इनका डेथ हो गया तो इनके लीगल हेयर्स को हम पार्टी बनाए।
तो मेन अपील को ही उस तरह से तब ऐड कर दो,
तो तब तक उसका डिफेक्ट इग्नोर होगा, लीगल हेयर्स को नोटिस होगा, ऐसा कैसे आप बनाए हैं?
लीगल एयर्स को अपील करवा के वकालतनामा भी हम ही लोग दे देंगे, उस तरह से एक नियम को ऐड करते हुए मेन अपील में पार्टीज बना देंगे और उसमें लिख देंगे डायड नाउ। Pursuant to the defect pointed out by the stamp reporter, now the IAs have been filed. कि आपने डिक्री में उन लोगों का नाम है, आपने एपलेंट क्यों नहीं बनाया?
देखिए आईए नंबर 10380/2023।
और एक हुजूर और है, एक लाइन खाली बोलना है।
This interlocutory application has been filed in connection with four appellants who were appellant number four persons who were appellant number 2, 3, 10 and 11 in the title appeal number 32 of 2007, in which the impugned judgment has been passed. The learned counsel has submitted that the appellant number 10 and 11 before the learned first appellate court, namely Love Kumar
and Kush Kumar,
namely Love Kumar and Kush Kumar, both sons of Sitaram Mehto, died on 6/7/2009 and 27/7/2017. And the appeal was decided on 27/3/2018. He submits that on account of their death, they have not been made party in this proceeding. In view of the aforesaid fact, the defect in connection with appellant number 10 and 11 of title appeal number 32 of 2007
No.
is ignored. However, the consequence of not substituting the appellant number 10 and 11 at the first appellate stage will be last sentence. It is not clear as to why no explanation has been furnished as to why the appellants of title appeal number 32 of 2007 did not take any steps for substitution of their co-appellants who were appellant number 10 and 11. Apparently, the title appeal number 32 of 2007 stood abated in connection with appellant number 10 and 11 of the title appeal.
No.
So far as the appellant number 3, 2 and 3 of title appeal number 32 of 2007 is concerned, it has been submitted that appellant number 2 had expired on 12/7/2018 and appellant number 3 had expired on 1/4/2018
No.
after passing of the judgment.
First appellate.
Passing of the first appellate judgment. However, the decree of the first appellate court was drawn on 13/4/2018. The learned counsel submits that on account of this aspect of the matter, the appellant number 2 and 3 of title appeal number 32 of 2007 have not been made party in the present proceedings. Through the interlocutory application, a prayer has been made to increase the legal years of appellant number 2 and 3 of title appeal number 32 of 2017 as party respondent in the present appeal. Issue notice to the legal years and successors, to the proposed legal years and successors of appellant number 2, namely Surajmani Devi, and appellant number 3, namely Vinodal Devi, who are said to have
As detailed
expired
in para 3
prior
and
to the
5.
judgment dated 27/3/2018. The names of their legal years and successors have been mentioned in paragraph 3 and 5 of the interlocutory application. It is expected that their death certificate will be placed on record. The requisites will be filed by 6th of January 2027. Sorry, 2026. Under scheme post. Okay, in ID number 10380/20.
मिला। एक और आई है मिलर,
बताइए।
उसमें
इसमें अभी तक नोटिस नहीं हुआ है, इसमें इतना दिन से चला रहा है। इस आईए में और बताइए
एक और आइए हमारे
बताइए
6255
6255 आप बताइए ये क्या है?
इसमें एप्लीकेंट नंबर 1 जो अभी है सेकंड अपील में, उसका डेथ हो गया ड्यूरिंग पेंडेंसी ऑफ दिस सेकंड अपील, उसी का सब्स्टिट्यूशन फिर ये पैरा 3 में सब लाए 25/5/21 का डेथ हुआ है पैरा 3 में, दीप नारायण महतो, एप्लीकेंट नंबर 1 ड्यूरिंग पेंडेंसी। इसमें डेथ सर्टिफिकेट दिया हुआ है।
IE number 6255 of 2021. This petition has been filed for substitution of applicant number 1 namely D. Narayan Mehto, who is said to have expired on 25/5/2021. The surviving legal heirs and successors has been mentioned in paragraph 3 of the interlocutory application. सारा का वकालतनामा फाइल कर दिए। The council has submitted that the wakalatnama on behalf of the proposed heirs and successors have been placed along with the interlocutory application, and the death certificate has also been placed. He has also submitted that in the meantime there was COVID-19 situation. Considering the government's made in IE number 6255 of 2021 seeking substitution of applicant number 1, the prayer for substitution is allowed. The council for the applicant is directed to delete the name of applicant number 1 from the first title and insert the name of his legal heirs and successors in writing during the course of the law. और क्या है?
एक और आइए, एक लिमिटेशन पर
395 कितना दिन का डिले है?
बहुत दिन का डिले है, 297 डेज है। खबर नहीं हो पाया ब्लॉड, उसके बाद आके यहाँ जब आए इंस्पेक्शन किए हैं तब पता चला यही लिखा हुआ है।
कुछ है ही नहीं आपके इसमें। डिले कंडोनेशन कोई एक्सप्लेनेशन ही नहीं। There is no explanation.
इंफॉर्मेशन नहीं मिल पाया, पैरा 2 वगैरह में यही came from his village home,
They have no information about the dismissal of the appeal.
खबर नहीं था उधर, और इंस्पेक्शन जिस दिन फिर आके किए हैं तब पता लगा कि 15/2/20 को।
तो आपको जब मन होगा तब आप इंस्पेक्शन करेंगे, जब लिटिगेंट को जब मन होगा तब वकील साहब से पूछेंगे। 10 साल बाद भी पूछेंगे तो सेम ग्राउंड रहेगा ना सर, ये पता नहीं चला। ये कोई एक्सप्लेनेशन है क्या? लिटिगेंट इज सपोज्ड टू बी विजिलेंट। 2 साल तक आपका कोई कांटेक्ट नहीं है वकील साहब से। This is the explanation you give. कुछ नहीं, आपके मेरिट में भी आपके केस में क्या है आपके केस में? कुछ नहीं। बताइए मेरिट में है कुछ? एक शब्द भी है मेरिट में?
सॉरी
एक शब्द भी मेरिट में कुछ है?
मेरिट पर अभी देखा नहीं है।
हम देखें ना।
तो हम भी
लिखिए IE number 3954 of 2023. This petition has been filed for condonation of delay of 297 days in filing the second appeal. The petition appears to be sketchy and does not contain due explanation for condonation of delay. However, the counsel for the applicant has submitted that the matter be adjourned and be taken up after appearance of the legal heirs of the applicant number 2 and 3 who were party in the title appeal number 32 of 2007. आपका यहाँ पे सबमिशन यहाँ पे था पिछली बार that they have expired during the pendency of this appeal. This was the submission.
2 and 3.
2, 3, 10 and 11. नहीं ठीक है कब रख दे बताइए
जनवरी में
पोस्ट ऑन 7 जनवरी रिक्विजिट फाइल कर दीजिए बाय मंडे स्पीड पोस्ट
बाय लॉर्ड
बाय मंडे ऑर्डर साइन करा दीजिए
Item 63, second appeal 94 of 2020.
Where is the counsel? Essay number 94 of 2020. The case was posted for today by order dated 6/12/2025. However, by slip dated 18/12/2025, a prayer has been made to adjourn the case. Today, and further a prayer has been made that the matter be listed on adjournment date. Nobody appears on behalf of the applicant to move this case. Let this matter be posted on 5th of January. It is made clear that no prayer for adjournment will be entertained on 5th.
Item 64, second appeal 145 of 2023.
Yes,
There is a RJ pending.
आइए कौन
Limitation.
लिमिटेशन नहीं सुनी मेरिट सुनी बताइए लिमिटेशन कितना दिन है आपका?
22 दिन 22 दिन
22 दिन मेरी
मेरी फिर छुट्टी के बाद
नहीं पिछली बार यही बोल कर था आपके सामने ऑर्डर किए थे ना नहीं थे तो हु इज रिस्पांसिबल फॉर दिस 6/12/2025 को Learned Counsel for the Appeal seeks adjournment to advance his argument on the merit of the case as well. संतोष कुमार
करेंगे छुट्टी के बाद
नहीं।
छुट्टी ऑर्डर
नहीं एडजर्नमेंट नहीं देंगे बिना कॉस्ट के एडजर्नमेंट नहीं देंगे कॉस्ट दीजिए एडजर्नमेंट कीजिए choice is absolutely yours वो तो हमको जो मन करेगा हम करेंगे आपसे पूछ के नहीं करेंगे कब करना पड़ेगा
छुट्टी के बाद कोई
कोई भी दिन मतलब कौन सा दिन सेकंड वीक से कोर्ट खुल रहा है
फर्स्ट वीक से
बताइए कौन सा दिन आप बता दीजिए कॉस्ट हम लगाएंगे तो दिन आपकी चॉइस कर देंगे बताइए which date Six. Second appeal number 145 of 2023. The matter has been posted today by order dated 6/12/2025, wherein the counsel for the appellant had sought adjournment to argue the case on merit as well. Today, when the case is taken up, the Learned Counsel for the appellant seeks adjournment by submitting that he is not ready to this. No advance notice has been circulated seeking adjournment. However, in order to give one more opportunity by way of last chance, at his request, the matter is directed to be posted on 6th of January 2026 upon payment of cost of ₹5,000. The cost should be deposited latest by 5th of January, failing which this appeal will stand dismissed without prejudice.
काउंट कर दिए हैं
Cost वो advocate कम नहीं था 5,000 से तो कम
2000
एक जीरो लग सकता है
2000 कर दीजिए
Item 65, second appeal 92 of 2024.
Yes, appellant.
degree of 95%.
Yes, you are the minutes.
This is judgment of affirmance as of the plaintiff in the court below. Suit was dismissed. Plaintiff suit has been filed for declaration of right title interest and for declaration of deed of 10/10/2007 as null. Plaintiff is by trust alone. The case of the plaintiff is that when Michael Loro was the owner of the property, he died issueless.
Self-acquired property.
Lord, plaintiff says that it is ancestral property. The
No.
defendant it says that it's ancestral property.
It is a self-acquired property purchased by from a person who is not a client.
Lord, in the evidence it says that it's the ancestral property of the father.
It has been purchased by a registered deed.
But there is no deed on the property.
Yes, yes, of course.
Sorry, but there is no deed.
Let's see.
It's only an amendment of 1958-1960. The property was
Just
purchased.
a moment.
Yes.
You see, the land was Rayati land of Abdul Mina.
Lord, it is a stand of the defendant.
You are the plaintiff.
I am the plaintiff.
Yes. They are not exhibited this deed.
Yes, ma'am. This deed is not executed.
This deed number 5/7/1958
No.
and deed number 16/8/1960.
Sorry, but this is not the executed.
Not exhibited.
This is a stand of the defendant. In my case is Lord that this is the property of the ancestral property and the Mekhalana was
It
the
has been exhibited. Exhibit C,
exhibit C Lord is the
1960.
yes.
Kadir Bakshi,
Yes,
yeah?
yes, yes.
It has been exhibited.
Yes,
It
I'm
is a
sorry.
self-acquired
I'm
property.
sorry, yes. It has been exhibited.
It has been exhibited. They are claiming the property by virtue of a registered deed executed by a non-tribal in
Yes.
favor of a tribal.
I'm sorry, I understand correctly.
Then?
Yes, it is. Therefore, Lord, the property Lord is owned by Mekelo now. He died issueless and leaving behind his widow, Lord, defendant number 1, and 2 sisters, Lord, who is unmarried. Lord, the further cases, Lord, that this widow defendant number 1, Lord, sold out the property to the defendant number 2 by virtue of registered deed after taking permission of the DCI law in year 2007. And thereafter, Lord, suit was filed in year 2013. Defendant appeared, Lord, they filed a WS. Defendant number 1 has only appeared, Lord. In the judgment, it says, Lord, the defendant number 1 and 2 jointly filed written statement. But I have the office copy of the written statement which says defendant number 1 has only appeared, Lord, and filed written statement stating that this the property was purchased by the Michael amount and I am the widow and I sold out the property. Lord, may kindly have, Lord, the issues, Lord.
No, I just want to know that this is a self-acquired property. Then under such circumstances, how customary law will govern? The widow is claiming the property.
Yes.
Yes. Throw some light.
Yes, but I will just before I come to that number. Page number 5 will kindly be seen at page number 18. Issue number will not page number running page 18. The
18
trial 18 of the will not appellate court judgment. This concurrent finding. Not page number 13, sorry, page number 13. 18 page number is confusion. Page number 13 circle. Yes. Lord, the trial court formulated, Lord, 5 issues, 5 issues. Lord, out of which, Lord, the issue number 3, which is
Page number 13 is not referring to
running internal page 5, judgment page number 5, and certified copy page number is 18. As a lordship. Lord, there are altogether 5 issues. Lord, issue number
defendant number 3 did not appear.
yes,
This is a deputy.
and 4 is a deputy commissioner.
4 is a deputy.
Yes. Lord, issue number 3, whether this suit is land belong to defendant and defendant number 3 has right to execute sale deed dated 10/10/2007. And Lord, second issue is whether the right title, whether the plaintiff has right title possession of suit property. So these are the 2 main issues, Lord, which has been found. I mean, Lord, these 2 issues have been, Lord, answered in favor of the plaintiff. In spite of the same, Lord, the suit was dismissed. And other are the formal issues, Lord. Whether the suit is maintainable, cause of action, court fees. The main issues, Lord, have been answered in my favor, Lord.
There is the answer to issue number 3. This particular, what was the relief for?
It was suit for declaration of right title interest and for declaration of sale deed of 10/10/2007 as null and void.
Null and void.
Yes, not for cancellation.
So this particular deed has been held to be null and void.
2007, yes.
Where is the finding?
Yes. I will kindly take a look at the trial court judgment. I'm sorry. Issue number 3. Issue number 3, finding is at page number 41. Sorry. Lord, issue number 4 has been decided first, and Lord, this is page number 46. On the basis of the facts and circumstances, plaintiff has failed to prove right title interest in further suit, therefore issue is decided. I'm sorry, this is against plaintiff. I'm sorry.
It has been decided.
Yes. I'm sorry. Lord, this is the second issue, Lord, issue number 3. Issue number 3, Lord, is page number, para number 8. From the perusal of the case record, it appears that defendant number 1 executed sale deed in favor of so and defendant number 2 after receiving the consideration amount which is marked exhibit 2 on behalf of the plaintiff and exhibit A on behalf of defendant number 1 and 2. The suit property was a self-acquired property of the deceased Michael Arrow. After the death of Michael Arrow, the wife, namely Johanne Arrow, succeeded aforesaid property and acquired right title interest in possession of suit property. Later on, executed deed exhibit 1A. Such due to being self-acquired property of Michael Arrow, the widow acquired right title interest in possession. Therefore, she has right to execute sale deed. That is so and so. In favor of exhibit, therefore she has right to execute the aforesaid deed. Exhibit 1 in favor of defendant number 2, namely so and so. Not thereafter will claim to such an advocate. It is admitted that both the parties are tribal by community. Witnesses will fully establish that they are governed by the tribal laws. Any woman of the Warao community has only a limited right of maintenance of any property. As such, the learned counsel for on behalf of defendant number 1 and 2 failed to file and produce a provision or citation of self-acquired property has not been covered or governed by the tribal law, and the lady has full right to interest in possession. On the basis of the aforesaid facts and circumstances discussed above, defendant number 1 has no right to execute sale deed. Defense counsel in favor of defendant number 2 on the basis of the aforesaid facts, circumstances. Issue number 3 decided in favor of plaintiff and against defendant number 1.
Self-acquired property cannot be sold.
Now, this is the finding which has not been challenged. This is the finding, my lord, which has not been challenged by the
You
defendant.
see, the defendant number 1 and 2 failed to file or produce any provision or citation.
Yes.
That self-acquired property has not covered. Who has to actually adduce this case? That the self-acquired property also cannot be transferred under the tribal.
Well, initially the burden is upon the plaintiff only. But there is a
Did you produce any customary testimony?
well, we showed only the customary law, we not that the Warao customary law, it says that the sonless widow cannot transfer the property. And they know the burden, when discharge the burden, will not the order shift to them, will not they as per their custom whether she can transfer the property or not.
So unless widow cannot transfer which property, ancestral property.
No, they royally silent will not in this respect. And against this finding, my lord, they did not prepare any appeal. Against this finding. Now, my lord, my issue is, my lord, the question of law is proposing. That, my lord, altogether, these 5 issues were formulated. My lord, the appellate court, my lord, for the first time, one issue was formulated by the appellate court. My lord, kindly take note, the issue what the points of determination have been formulated. The limitation issue was for the first time formulated by the appellate court. The points of determination. Which was never the issue before the trial.
Limitation is always to be considered by the court.
Yes, Lord. It has been
Irrespective
considered.
of whether
Yes.
it has been based or not.
Yes, yes. Lord, this issue was never issued before the court. When the matter was placed, Lord, if suppose, Lord, the judgment has been delivered, Lord, I preferred an appeal. If this point of determination is not mentioned in the previous order before passing of this particular judgment, I cannot address on that particular issue. Lord, for the first time, while dictating the judgment, for the first time, this issue was formulated and the suit has been decided against me. Appeal has been decided. Now, how can I
Where
get
is
this
the
point?
point for determination?
Lord, page number 18.
Page number
Page
18 of
number
the appellate
18,
court judgment.
appellate court judgment, Lord, and the internal page is 10. And certified copy 23. 23 by 37. And para number 13.
First.
So Lord, the issue is at page number 13. 1 3.
They have raised a point that
Yes,
this
they
is
have.
barred by limitation.
In the pleading, Lord, they have taken the
They have
suit is
taken a
barred.
plea, it is barred by limitation.
Suit by is barred by limitation they have taken, but this there is no such issue, my lord. I could not
Need
address.
not be,
Yes.
a court is supposed to address on the point of limitation.
Yes, if this issue was not there, I could not address this issue. If the appellate court finds that this particular issue is required to be answered, they should have provided me an opportunity to meet this. At the time of taking the judgment, for the first time this issue has been formulated. How can I meet this point? Therefore, I was praying, this is a fit case when the first time the issue was formulated by the trial court. This should have been matter, should have issue have formulated, matter should have remanded back.
See, the point of it, at the stage of trial, the issues are framed and the parties leave. But at the time of passing the first appellate court judgment, the parties, they argue their case, and the court at the time of deciding the case formulates the point and then decide, depending upon the argument of both the parties.
Yes.
Right? There is no such system that a point of determination will be framed and then the parties will address the court. That is not the procedure
Lord,
so
here
far
in
as the
this
first
case-
appellate.
Yes, here in this case, this was never an issue, the limitation. I could not have addressed this particular issue.
No, it was very much there. What is the evidence?
The issue, the trial court issue, the issue which has been formulated, which was never the part of the issue. This has answered me, Lord. I was only proposing, I have just formulated two questions, the Lordship, so please can have look, and I will address, that they have guided, that Article 59 of the Limitation Act would be guided, and therefore limitation is 3 years. In my humble submission, the Article 65 would be governed. And the limitation would be 12 years. Page number 20 is para number 20 onwards there is a finding. Very. Yes.
There was an argument also to this effect. There was a specific argument that it is barred by limitation. Okay. Para number 21.
But this is the plea taken by
Not the plea. It has been argued on behalf of the respondent number 2, dependent number 3, challenging to simply it is barred by limitation. It is not that the councils did not join issue and they did not address on the point of limitation. It's not like that.
Now, the issue was formulated under the trial court, and it has been stated that the suit is barred under Article 59 of the Limitation Act. They should have been preferred within 3 years. I have filed a suit in year 2013. Therefore, it is barred. Now, in my humble submission, Lord, kindly have para number 24 onwards. This is how the finding starts from here. May I please?
Para
24 page number, internal page 15.
Yes.
Section 31 to 33 of the Specific Relief Act 1963 mentions that when the sale deed can be cancelled, plaintiff has prayed that the sale deed number so and so exhibit 2 can be declared null and void. The plaintiff was present in the suit for the plaintiff has filed the present suit for cancellation of sale deed, but it is wrongly mentioned. It is for declaration null and void. The report was in the impression that it is a cancellation. I have a certified copy of the claim also. Can you please?
That's right. That's right.
Under Article 59 of the Limitation Schedule to the Limitation Act 1963, the suit filed for any declaration is to be filed within 3 years when the right to sue occurs. Under Article 59 of the Limitation Act, suit filed to cancel or set aside the instrument or decree, the suit has to be filed within 3 years from the date when the facts entitling the plaintiff to set aside or cancel the instrument or decree became first known to him. In the present suit, after completion of more than 3 years, the suit was filed by the plaintiff. PW1 plaintiff was cross-examined in case of so and so. In a cross-examination, para 15, she has stated that विवादित जमीन को करीब 20 साल पहले जोहानी ओराई बेच दी थी. जमीन उक्त जोहानी ओराई से प्रतिवादी संख्या 2-3 मोबिल इसकोटा तथा सोवेंसो ने आज दिनांक 20 से 25 साल पहले खरीदा था तथा तकरारी उक्त जमीन पर अपना कब्जा लिया और मेरे खाने पीने के लिए उन्होंने कोई जमीन नहीं छोड़ा, इसलिए मैंने इस जमीन के लिए अपना दावा करती हूँ जिस दिन उक्त विवादित जमीन को जोहानी और आइन ने बेचा था उस दिन मुझे बिक्री की जानकारी हो गई. To sum up, the plaintiff is silent when she came to know about the sale deed, and affidavit of the plaintiff is filed. For example, she is completely silent on this point. In the cross-examination, she has admitted that she came to know about the sale deed at the time of execution, that is the sale deed of the 2007, and the suit has been filed within 3 years from the date of knowledge and of the sale deed, but the suit was filed in 2013. There is neither pleading or evidence to show that there was a justifiable cause for not challenging the sale deed within 3 years. Apparently, suit was filed in 2013 and challenging the sale deed of so-and-so is beyond the period of limitation of 3 years prescribed by Article 15 of the Limitation Act. Hence, I hold that suit is barred by limitation on coming suit. Lord, if the suit has been filed, I am not the executed on the deed. Lord, therefore, limitation I have to file for suit to declaration deed as a null and void. If it would have been cancellation, if I would have been executed as per the Surit Singh judgment, then I would have to file a suit within a period of 3 years from the date of execution. Lord, this is Surit Singh judgment. Para number 6. Now, my lord, my question is, my lord, the court has been said, my lord, that this is almost second half. Can you continue second half?